rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found in connection with the shackling issue that the publicity in this case is likely to reach jurors who will be part of our jury pool. And we've also submitted to the court a public opinion survey which shows that the prejudicial publicity that the media has already generated in this case has affected the jury pool. And so those are all factors the court can point to and rely on and conclude that publication of this particular exhibit should not be allowed because there is a realistic likelihood of prejudice to Mr. Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
Thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. You know, it's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, you know, controls here as to whether in this public proceeding it can be closed in any way, and non-publication of exhibits as a form of closure. So I don't necessarily disagree. I would just underscore a lot of what Mr. Burt just said has been briefed ad nauseum at this point. Their position that publicity is incompatible with a fair trial. The Allgaier case he mentioned, you know, I know that case. I litigated that case. It involved a confession that the court found public because you have so many other tools to seat a fair and impartial jury. And we have cited that case repeatedly, and so has Your Honor, I think, recognized it in your ruling, saying pretrial publicity can coexist with the defendant's right to a fair trial. So the last thing I'll say is just that the constitutional standard that I think we're all agreeing applies here is weighty and difficult to overcome. And it is never satisfied, as we've explained, by just generalized assertions that there's a lot of publicity out there. It's got to be something really specific, and they just haven't made that showing. And I certainly don't think that a video that apparently just shows the defendant walking around the UVU campus qualifies.
Thank you. Anything further?
Judge, from the state, no, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with Your Honor.
Thank you. I appreciate that clarification, as it is guiding for this court in making its ruling. I turn to Utah, well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records include but are not limited to, and I'm going to go down to 2J, exhibits, but the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature, and those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. And we can proceed.
Thank you, Judge. Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low-C building. Is that correct?
Yes.
I believe you also testified that you began by working your way, and this is what I remember you saying, so correct me if I'm wrong, but you in essence testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
Did you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
Okay. You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt, that is, to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess.
Yes, on each occasion we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor what you're going to see is a paused or a still image And I'm going to ask if you recognize what, you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run. And then if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet. Maybe
Oh.
you're-
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
All right, and where does he go from there?
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I've previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
Please repost the space, everybody. Bottom right corner. Thank you.
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video. And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored t-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building and purchased some food, sat and ate the food. Then, I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes
then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
And from there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
Was he hiding the gun in his shorts?
Were you able to refresh your memory as far as the time?
I was, yes.
Okay, and what time was it?
It was just prior to 11 a.m. when he walked off campus.
Okay. And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have are from my viewing and seeing Mr. Robinson on the video, it's the same person.
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
This is Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, were you able to track Mr. Robinson when he leaves this parking structure?
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there's a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this particular video.
All right. So right now, if you were to break this picture into quadrants, where would he be?
He'd be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
Okay. And what time is this?
It's just afternoon, about 12:15
On what day?
on September 10th, 2025.
Okay. What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right? Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes,
So we're
2025.
clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. And they move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, the almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
What do we see now?
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
Okay. And on the screen, where is that vehicle that you're referring to located, if you broke it into quadrants?
It's on the left side, on the upper side, the upper quadrant.
Now what do we see?
And that vehicle's now pulling away and heading east on 800 South.
And why do you believe that that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail,
Okay, and do you know who that officer is? or
Officer
was?
Goforth,
Okay, and do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay, and what time was that interaction? I'm sorry, did I ask you that?
It was approximately 12:30 a.m.
Okay. On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, or during, I guess during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that, I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that vehicle, or a vehicle matching the description of that, was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information,
Yes, he ran a partial plate.
okay, a license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes,
And did he tell you who the owner of that vehicle was?
he did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Okay. Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1, and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlights.
Yes.
Do you know what he's, or what is he referencing by the red highlights, or what do you believe he's referencing?
I believe he's referring to red ovals or circles that were placed over the image to identify specific individuals of note.
And these red circles, are they permanent red circles? Are they temporary?
I'm
Different.
I would assume they are temporary. I'm not very technological, but I believe they would be overlaid over the image.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video. But
All right. And other than, well, and you said that the circles, what do the circles do?
they identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights, do they do anything with regards to the video itself, as far as its accuracy?
Not to my knowledge, no.
Okay. I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that? Tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage, and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
Okay. And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, does at least that enhancement to the video, does it change the content of the video,
No,
the accuracy of the video in your mind?
no.
Okay. Are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1, are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original focal point gives.
So let's talk about the zooming in and the zooming out. It sounds like it's specific to the low-C rooftop, if I understand you correctly.
Yes.
Okay. And I think we've all watched that exhibit.
Correct.
4. And although you can see Mr. Robinson and his movements, is it fair to say that it's difficult to really see what's going on?
That would be fair, yes.
Okay. And the version that's in 12.1, does it facilitate at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps?
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, the foundation that was laid yesterday, including the written statement from Mr. Olson, which has been admitted into evidence and is, well, it's already been admitted into evidence. We believe there's enough foundation that at this point we'd also ask the court to admit what's been marked State's Exhibit 12.1. We think it would be well, beneficial for Your Honor to view it.
Ms. Nestor.
Thank you, Your Honor. We renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4
Well,
words,
I
unless
can
you
read.
want to share that
I
with
can
me.
read that. Or
Okay, go ahead and
needlessly
read that.
presenting cumulative evidence. So the court may. Let me just read the whole rule for completeness. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. I'm not looking at anything else other than that last portion. I recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision or you've zoomed in on that monitor, you really can't see what Agent Hull has just described. The character of 12.1 is it simply, it enhances that at least important parts of that exhibit, and it just makes it easier to see, not only by Your Honor, but also by the public. And specifically as it relates to the zooming in and the zooming out.
Okay. Anything further from the parties as it relates to 12.1? All right. Well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on the television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. And if it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations, the court does not find that the interests of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom.
Yes.
Can I make one suggestion, Judge? Or maybe one run request? I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that, if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video.
He wants to use the
that's
edited version of the
really,
video to make
the
Tyler
thrust of
Robinson look
why we are
suspect.
trying to introduce that exhibit, because
I see.
we believe that
Wild.
it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it, and then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in, how long is that, Mr. Sturgill?
If she doesn't challenge this, we'll
I
know
think it's a couple of
she's
minutes.
bought.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right, thank you, I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at, so all parties can see clearly that the court is reviewing it in court. But I do not find that it is necessary for its publication, because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights, and there is nothing on this video from what's been represented that the public hasn't already seen. It's simply zooming in, and I don't find that that is necessary, or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
Great, I appreciate that, Judge. I respect that. I think there's a natural break where we can start. And what I'm going to ask is just we simply play the low. You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I
Okay.
will. All right, whenever you're ready. Counsel, as it relates to your monitors, just as a caution, if you don't want it to be wished to be picked up, and I'm not saying it will, I know there are camera operators being diligent in ensuring they're complying by the rules, but in abundance of caution, this is just your moment to take care of your screens if you feel the need to do so.
Sure, if I could just have one moment. Hold on, Kimberly. Not sure where the power button is on this. There we go.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right, thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom. And you may present 12.1, the portion you wish for me to view. And just for the benefit of the record, do you want to put on the record the timestamp of what you're playing, at what point you're starting and stopping? As we go, or when we finish is fine. I just want the record to be complete.
Just the difficulty in doing that is because we've zoomed in, it's removed the timestamp on it. And so-
Well, you can just give me the
count
The
on the
count
video?
on the bottom. There's a timer at the bottom of the total length of the video, so that's fine. I'm just trying to create a record of what exactly I'm looking at.
You guys go check out the updates I have up in the Jumbotron, and please repost the space. I got Charlie Kirk's parents on video when I was at the courthouse this morning. Without Erica Kirk.
Oh,
Go
I
check
see.
that out.
No, it's limitations of technology sometimes. Thank you for letting me know.
So the count on the video is just before 6-minute mark, Judge.
All right.
And just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
All right, and it's been paused, it looks like, at 6 minutes and 23 seconds.
I'm sorry. Judge, at 8:23, we stopped the video.
Oh, 8:23, okay.
8:23. That's the count on the video itself.
Thank you.
Okay.
All right. Thank you, Mr. Sturgill.
Agent Hall, you were able to watch that zoomed-in version, is that
Yes, sir.
right? Okay, and was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing?
Object to leaving.
strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Well, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
One moment, Your Honor,
Of
if I may
course.
have the court's indulgence. Thank you. Do you want to take your?
And I was just going to suggest that. It seems like right now is a good time to take our morning break. It's 10:15. Let's come back at 10:30, and we'll resume with cross-examination of Agent Hull. Court is now in recess.
Well, that you cannot tell who that is. That could be half of the people on campus. Like it is. This is just crazy. I think the most interesting thing for me is the fact. Oh, it seems to be frozen. Or YouTube's really lagged today. I'm not sure which it is. It's crazy to me that. Did you guys pick up on the fact that he met with TPUSA representatives when he got there that morning? Did you
He
hear him
met
say that?
he met with Israeli representative.
David, bro, can we just get to noon? Come on, man. It's not. Can we just get to noon?
I'm sorry, he met with these special people.
He's. They said that he met with TPUSA when he got there. Was he getting instructions? What's that about? That's interesting. Let's listen to that clip real quick. That's news to me.
Into the campus.
From there.
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area from there.
Why do they just skim over that? Like it's no big detail. What do you mean he makes contact with members of TPUSA? That's huge. What? Which members? Was it Cooper Brown? Was it Andrew Colvett? Who was it? Was it Blake Neff? Who did he meet from TPUSA? That's weird. Why are we just now hearing that? That's massive. That's up in the Jumbotron. Make that go viral. Everybody needs to hear that. Please go share that. It's up in the Jumbotron on my profile. That's crazy.
He heads out of the parking garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area from there.
He just completely glazed. The prosecutor acts like he just didn't say met with members of TPUSA.
He's saying that Tyler Robinson met with members of TPUSA.
The morning that Charlie Kirk got assassinated. That's exactly what he's saying.
That would be a question for the judge, because that applies to both sides of this, right? The judge should be like, whoa, wait a second now. Did you just say that Tyler Robinson met? I mean, that would have been like when you meet with someone, you're looking at them like a foot away, not a long camera strip. So you would ask, which members? Who was the guy?
And not only that, right? Why did Catherine Nestor not have him elaborate on that? Why didn't she say which? This is why I think that, again, pay attention to the details, right? When it comes to this defense attorney, I think that she is doing just good enough to be passable, right?
Do you know what word she says the most?
Yeah.
He says over
This is a 30-year law veteran, right? She's been doing this for 3 decades. there is no reason she should not be asking who he met by 2PUSA, right? That is a huge detail. And you have the opportunity during cross examination, right, to ask that. She better ask it. She better ask it because that's crazy to me. That's absolutely crazy to me. She gets to cross examine. We will know. If she does not ask about that, she is on the take. 100%. Go ahead, Noah.
Gray Space is diligent. Thank you for doing this. Thank you for being out there in Provo. It is weird country out there, isn't it? Uh, I got a question. How was the prosecution able to ask the witness if that was if they recognized Tyler Robinson holding an object in that video? How are they able to say out loud that that is Tyler Robinson, implying that it is in fact Tyler Robinson? That is crazy.
I don't know. Are you? How are you able to ID him? Well, I mean, so the prosecutor can ask whatever questions he wants, right? But she can object, right? So why is she not objecting on the ID, right? How can you positively ID him? Now she can
100%.
cross examine, and so the judge may say you're going to have to wait until to your chance to cross examine because that might be a question of accountability or credibility. So I'm not so sure. Like I'm not an attorney. If I had to guess, she's saving it for cross examination. But one, she better ask how he can ID him. The reason why they wanted to show that enhanced video because you remember when there was two screenshots of the stairway going around. One was a really smooth face and looked just like Tyler Robinson, almost exactly. And then the other one was like the Bigfoot quality, very pixelated, very blurry video screenshot. That's the enhanced one they want to show everybody that looks just like Tyler Robinson, right? And it's completely it's AI. It's actually AI enhanced. So and he keeps trying to do that. He keeps trying to insert enhanced and AI footage. Why? Why? Because the evidence you have is not good enough to convict? That's why. That's why. That's why he wants to do that. 100%.
It's
Well,
so
not
100%.
important.
any
It's so important.
AI generated video has to be kicked out 100%. The second thing is what were the blurred faces? They mentioned something about blurred faces. I didn't get to see that, but some faces were blurred out. Okay, who are those people and why are their faces being blurred? To hide identities of people who are not relevant to the case or to hide identities of someone who may be relevant to the case? And the other thing I want to ask is, Diligent, if she steps up to the stand and the first thing she doesn't ask is what was Tyler Robinson, and the term they used was, it wasn't meet, it was had contact with, something like that. It wasn't it met with them, it was had, you'll have to go back and look at it, but it's something like had contact with, it wasn't met with. But those two words that they used there were very important. And so that is something you really have to get out viral because that is so big that he had contact with TPUSA officials. It's just, I don't know, I'm gobsmacked. That's all I can tell you. Thank you for the mic.
Yeah,
There's,
that's a huge detail.
I think, Miss Lee, to your point, like we've already seen this in other cases, probably in the past year or so, especially where they're trying to get AI enhanced and saying like, well, just because AI is enhancing it doesn't mean that blah blah blah, whatever. And that is going to be a problem. They're going to have to make rules about and rules of evidence because it's like you get it on one hand, right? Like a lot of us understand how AI works, but to what end and to how much does it change it? How much can you trust it?
AI
It's
can,
something that they're
AJ,
gonna have to.
AI to come, they could put Mel Gibson's face in
Yeah,
there
no,
and
they
have it
can
look
completely
completely.
alter
I
it,
mean,
or
it's,
it can
it's,
actually enhance, right? Because when
yeah.
you think about a lot of the programs that we traditionally use, that they use in investigations, is going to be enhanced via AI. We know that images aren't exactly images. Detective changes and
I don't use AI to enhance images when I'm
no, I know
investigating.
you don't. I'm saying in investigations, things like this have been used to enhance and see, and some of it
They should
helps us
not be.
see evidence. Well,
But
I mean,
AJ,
again,
usually when they do that, it
this is a
usually it's a
path that they're
first,
going to go down. It's the same thing that they do with
yeah.
DNA and finding
They should
people.
just make it. It has to be original. That should just
With
be
all
it.
this
If
in the
unless
Exactly.
Idaho,
unless unless
Marvin, right?
you're just adding like lines or a circle to highlight a specific part, it should be original quality.
Well, even then, that's a slippery slope, right? Like, again,
Even then,
anything that you're adding to something is gonna only
it should
become
just be
a
original.
bigger
It should
issue.
just be original. It should
But
just all be original.
the thing that stood out to me so far, though, this morning is his insistence on getting it played for the public. He wants the enhanced
Yep.
version played for the public. That means you're
Because it looks
looking.
like Tyler Robinson, but it's
Right. So
nothing
so
like
are
his
you presenting
original
evidence for the court, or are you presenting evidence in a case for the public right now? We
for the
should have
public.
access to it as a public, but what the judge should be concerned about is why are you trying to present and who are you getting testimony out to? His concern should not be the public. The public has access, so we can make our own determination. But you're starting to share, and he's being open about a narrative of like it. He makes it clear that that is what his goal is. He is being like a news organization and spinning a fucking narrative, and that should be. I've seen judges call prosecution and defense out for this type of behavior, so it's wild to me that they're doing that. And then again, the 1102 stuff is just fucking with me because it does, like, I understand that they have their own constitution that they'll go by, but going into why she continued to make those same objections, which seem crazy to us, because it goes against other constitutionality. So while in Utah it currently stands, it is important for the future of that law and how it may evolve. At some point, it could be 30 years from now that a court comes back and decides that that's not. So it's interesting as just like a general case law thing to start paying attention to what they're doing, because this law was updated, or these rules were updated last year. It's crazy. Like, just the timing, these little things, the timing is real. All these things are starting to, I'm making notes because all these things, if
Uh,
you can't ignore all those small
there's
things.
another part too that I noticed. He When the judge asked if there's a video of the shooting, they said no. The officer said no. There's no video of the shooting. All they have is them running across the roof. That means you don't know if that person took the shot.
It means they have no direct
100%.
evidence for
How
sure.
is that possible, though? How is that possible that they can release
It
this
can't be. It
figure?
can't be possible because that's a dome. I've been there. That's one of those dome 360s. It catches 100, at least 180 degrees, right? How can they not have caught it? That's a visible spot from where that dome is. I've been up. I was just up there yesterday. You can see the camera from that corner. How can they not have that footage? How? That's
Battery died.
crazy. Go ahead, Jill.
Convenient battery dying,
I think it's important to remember this is a preliminary hearing. If this is defensible evidence, then the defense wants it to go, if this goes to trial. The purpose of this hearing is to convince the judge.
Yeah, the judge that it's probable cause. Yep, I know.
So it all, and the 1102 just keeps a whole lot of professional people able to work for a week to just give the judge information of whether or not this goes to trial. It's not, they're not trying the case here. So to call out any of, she wants to wait and do that in deposition. She wants to do that in discovery. She wants to do that in front of a jury, not.
Yeah, but she can get some. She can get some meat. Listen, the prosecution is playing for the media. They should also be playing for the media, right? The prosecution has already been found in
That's fair.
contempt. The prosecution has already been found in contempt for biasing the jury, right? The only way that you can have a fair trial is for it to be balanced. So she should also be playing for the media. He is. She should be as well. That's my opinion.
And remember, there's an audience there. And don't think they're not going to walk. Those people that are there as just observers, they're not going to walk and be chatting about what they see and hear in this. You know, no different than a grand jury who's, supposed to be deigned to shut up and they don't. So, this is, no matter what, it's going to get out. And Diligent, you're right. These people on the prosecution, they know what they're doing and playing the media. Now, I'm just hoping that the defense is equally as canny. But Yeah, the revelation that he actually had contact with TPUSA. And was that before or after the shooting? Well, before, right? Be before the shooting that he had contact with the TPUSA team,
Yeah, it
right?
was in the morning at 10:30.
Okay, so that was just before. Okay. All right. Thank you.
That's a huge detail. That's huge. What were they doing? Were they sharing plans? Were they talking strategy? Were they discussing Tyler's future at TPUSA? What was he
A
They were
talking to?
just
deal.
they were
A
discussing
deal.
Chick-fil-A.
There's 3,000 people there, and he talks to TPUSA.
With Diligent, speaking of Chick-fil-A, I just had to call out. I don't mean to ever laugh during such a serious matter as this, but when they asked the guy on the stand, they said, "And what did he do after that?" And he goes, "Well, he went and got Chick-fil-A." And I just couldn't help but think of the Dave Chappelle skit where they play basketball with I think it's Prince. And then they're like, "And then what happened?" "Well, he took us and he made us pancakes." That's like what went through my mind when he said that. It just sounded so ludicrous. And the thought that somebody would, hold up a rifle, aim it at this guy's head, shoot him in broad daylight, run all around the campus to get away, and then be like, I really want a spicy chicken sandwich. It's all so insane that people even have to listen to this for what it's worth.
Ian, I must object. After I commit murder, the first thing I want is some juicy fried chicken.
Is it the waffle fries or the chicken?
Well, how many times did he eat? I just want you to think about this. He's 150 pounds. Okay, they're saying that he assassinated someone publicly, and that kind of anxiety does not make you eat when you're skinny, right? So they're claiming that he had Chick-fil-A, and then he went to Dairy Queen just a couple of hours later, and had a glizzy and a frosty and some fries, and then he drove 3 hours to Panguitch and had a steak dinner, right? And then drove back. What is going on here? Is this kid got a tapeworm? What's going on? It's
Well, in
insane.
all defense, Chick-fil-A does not serve Blizzies, so
He went to
extra
Dairy
trip.
Queen.
Yeah, he went to Dairy Queen for Blizzies. So Chick-fil-A does not serve Blizzies. So that extra trip from Chick-fil-A to Dairy Queen is justified. Absolutely.
Yeah, but he had a hot dog too. That's a glizzy, right? So I don't
Who
know.
did he meet with at Dairy Queen?
Turning Point
The
USA,
Dairy Queen.
obviously, but we shouldn't look into that either.
Yeah, don't bring that up.
And then later they give him a Scooby-Doo moment where they make the note, right? So he's like, "Well, I did this, and then I went over here, and then I did this." It's like Scooby-Doo they explain it all at the end so that you understand what really all happened. It's not really the ghost, right? And it's just also unbelievable. If this was all, if you didn't hear about this at all, if it wasn't a famous case and it was just on the evidence, you wouldn't have much evidence. This guy, the mainstream media is so oddly participatory in this because this guy has basically the narrative has been created in the media, tried and convicted. In fact, the media is sort of like, should he get the death penalty or should he not get the death penalty? And even the attorney looks like, I don't buy it. I don't buy an attorney is that dumb. I mean, I'm sorry, but she's a muttering idiot. This woman can barely talk. I've seen mimes that were only slightly less expressive. So I
David,
really,
it's so contradictory to your point about the media because Jack Posobiec was running around going, the far left killed,
yeah,
Charlie Kirk. And if the
exactly.
media is trying to protect,
Oh, I saw
yeah, I
good
mean,
old
it's
agent. I saw good old agent Jack this morning and
Yeah.
Officer Tatum. Mama.
I wanted, and I sent this out this morning, but I want to reiterate: there's no reason for Erica Kirk or the Kirk family to be so well, especially Erica Kirk, where it's so important that it's this guy. Like, remember, Jackie Kennedy said, "There's no way one dirty little communist did this alone." It Even if she's wrong, it makes sense where she's like, I want all the answers. And here's someone that says, I want none of the answers if it doesn't involve the little furry guy. So this all is just the idea that with Jack Posobiec, with Erica Kirk, with all of these people, it's so important, desperately important for it to be just this one guy. And it's just so odd.
Yeah, you'd think that thing that would matter with them is the truth. But oops, that's just too much. You know, whatever it is, if he did it, fine, we get the truth. If he didn't, fine, we get the truth. That ought to be the attitude. They politicize this so much, and it's ridiculous because that's where, you know, things get muddied, is when you bring politics in it and motives and all of that. How about just the truth?
But
Let's
that
get to
wouldn't be
that.
true if you were, but that wouldn't be true if you weren't, if Erica wasn't demonic, right? Because when Joe Kent said, well, we wanted to investigate the angle of a foreign country being involved with this. If you, a normal wife like Jackie Kennedy or somebody would go, what? Excuse me, what? Because Joe Kent said, but then they told us not to. That's when the wife,
We'll go
that's
ahead and
when the
pick up where we
righteous
left
wife.
off. I note that the
All right,
parties
here we go.
Yeah.
for each side are present in the courtroom, and we're picking up with cross-examination of Agent Hull. Ms. Nestor, your witness.
Really want to hear
please
Nestor's
support. Thank you.
questions.
Good afternoon, Agent Hall.
Good
You
morning.
and I have met before, but just to remind you, my name's Kathy Nestor. I'm one of the attorneys representing Mr. Robinson. So, when did you leave the SBI?
The State Bureau of Investigation?
Yes,
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that, or were you not
It's
involved in
not,
that?
no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I wasn't, I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the Losi building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th, yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're saying it was a
that's correct.
cartridge?
When a weapon is cleared, an officer would make his rifle ready, which would chamber around.
Oh, I got you.
My understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
Uh-huh.
I don't.
Was it a 30-06? Do you remember?
I don't.
Okay. Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent or what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
Sorry, got what wrong?
That he was the shooter.
The person I believed to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you?
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster? Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay, and just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13 and just show it only to the witness for right now? All right, can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day?
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay,
Is he talking about the handgun, I think?
thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there, there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline, is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
Looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
Okay. So, as of September 14th, Tyler Robinson had already turned himself in to the authorities, is that right?
Yes, I believe he turned himself in on September 11th.
So, prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was, is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation,
Okay.
or the second evening of the investigation.
All right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that, is that right?
Excuse me. Determine who he was or
No.
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct.
from the parking garage.
Correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone?
Yes.
It was not, no.
Okay. And in fact,
Repost the space,
video
people,
on the
please. Thank you.
roof- Well, strike that.
Bottom right corner, comment section. Thank you so much.
Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you, at some point in your investigation, collect from two young men who were present at the event a video that they had taken of someone on the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video, is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was, my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay.
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay. Thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr.
Are
Kirk.
you referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay, and can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Losi building. Is that fair?
I can't answer that question.
I,
Yeah, sure.
and Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that, at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that.
Okay.
But I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay, so what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured, and then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I
analyzed?
was not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report, no, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
Would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay, so you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay, thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my head.
Do you know how many fragments from the bullets?
I don't.
Okay. Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble, yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole... Sorry, just a moment. Let's see. Whole 48. This is Miss Noble's interview. Do you have it? All right, do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Okay.
That's huge.
I want to go back, if I can, to the scene itself, the preservation of the actual scene where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
No.
And were you involved in the decision to pave over the dirt that was under the tent?
AUVU?
Uh-huh.
No,
Did you know that happened?
only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct?
You received tips of death threats that Mr. Kirk had received before, the day before the shooting? Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay, and a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
Okay. And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement?
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in.
Okay.
In terms of what you've described, I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
She didn't ask about TPUSA. She's on the take. I told you.
I'm just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. Mm-hmm. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe, if that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded.
I believe they
But
were feds.
subsequently, specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how were they equipped? Like what type of equipment were they
I
carrying?
believe most officers carry a sidearm, a handgun, and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which
I'm
is
sorry?
we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. Once he had done whatever task it was that he was doing in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Okay. Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
Okay. And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars. So
Diligent, we
I
hear
would
you.
say hundreds, if not
hear your
1,000
private
officers. High hundreds. would have
Your mic's
responded
on,
to the
Diligent.
campus
We're hearing
that
your
day.
private call.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And
I just want to make sure I'm keeping the mic
I think
open
she
so
was
the
asking you
video stays
about Mr.
focused
Robinson
on.
just prior to crossing
Anyways,
Campus Drive, following the shooting. Do you
Yeah,
remember
yeah,
that
we just don't
question?
want to hear what we're not supposed to do.
Yes,
bro,
I
every
think I
time
was
you
asked
talk,
whether
it
he had a
focuses
gun
off
or I had
off
seen a gun
the
in his hand
camera.
in the
Mute
video.
up, mute up.
And you said that you did see something in
Thank
his
you.
hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point, after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail
It
what
appears
that item might
it
be?
appears to be black, and it appears to be longer.
Okay, anything else about that item?
That's what she said.
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video, is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent and then the rest of the courtyard. Is that fair to
Correct.
say? Do you remember seeing the banner
Yes.
in the video? Okay, and
You're referring to the back of the pop-up tent?
correct, yes.
Okay, yes.
Okay, and do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent? How would
No, you
describe
can't see through it. It's white,
Right.
and you cannot see through it, no.
it? And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. That exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
Okay. And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot, what's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Okay. Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the?
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
Okay. And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event?
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so.
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay. So identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Yes.
Okay. And that was the Washington County Sheriff's Office?
Yes.
Okay. You understood that he turned him, well, he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Nothing further. Oh, sorry. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the LoC building, is there, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
Thank you, Your Honor.
We have just a minute to meet with okay.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
Okay, so I was just texting Baron Coleman, and I think he's going to come in here. He was honoring the memory of his father today. And I think he's going to come in here. He is just blown away, same as me, about the fact that that she didn't ask about him meeting TPUSA. Why didn't Catherine Nestor follow up about that? That is a huge detail. And then the car, a bald guy and 3 other guys are driving. So he tells us about the Ring video yesterday. Remember the Ring video that he said was Tyler Robinson and Tyler Robinson's car, and he could tell by the wheels who owned it. And then today, the people who he got that footage from reported that the driver of that car was a bald guy. And there was 3 other people in the car. One of the YouTube comments, was it Blake Neff and Tyler Robinson and 2 other people? Who was in that car? That's crazy, bro. That's crazy. So here's what we have so far. We have grainy footage of Tyler Robinson. We've already seen pictures of. We have an officer telling us that Tyler Robinson met with TPUSA the morning of Charlie Kirk's assassination without any follow-up, without any investigation into that by the defense. We also have a bald guy driving Tyler Robinson's car, apparently, with 3 other people in the vehicle. What is going on here? Absolutely crazy. Am I missing anything? Mitch?
Georgia, what was the timing of the Ring camera when the multiple people were in Tyler's car?
That was the night of. That was later on that night.
So the question I have about the bald guy and 3 people, that's a really interesting statement. Is that seen in the video or is that their recollection?
That was the reporting of the owners of the house.
Of the Ring cam, right?
Yeah, but we didn't see all of the Ring cam footage. We just saw that specific clip.
Right. Okay. So the bigger issue is, people sometimes have failed recollection, but
You think that they failed to recollect the
let
difference
me
between
finish my
one
point.
person and 3 people, 4 people?
No, people could make mistakes. There's many cars that they're watching. The relevant issue is it seen in the video. Do you see 3 people? Do you see someone who's bald? Right?
You can't see anything in that video. What do you mean?
Well, I don't know if they have an enhanced version by the.
Enhanced.
No, seriously, I don't know. I'm just listen. It is extremely fascinating. When I heard that, I'm like, wow.
Every time
Is there a co-conspirator with them? Fine. That's
I've got to program a clicking noise, and he goes enhance. I'm gonna do that every time. Every time one of the lawyers tries to bring in enhanced footage, I am gonna be doing that. Okay.
I must have missed the part where can you explain what was said that he met with the people from TPUSA? What does that even mean? Like, he went to a pre-event event. He had a sit-down meeting with them.
He said he engaged with representatives of TPUSA. That's what he said. It's pinned
Yeah,
to my profile.
that's a really vague thing. Like, is he meeting with people in official capacity, or he's at a TPUSA event like, hey, I'm also someone, like, as part of trying to create a cover that he belongs there type of thing. Do you
Well, we
understand what I'm
have
trying to
no
say?
We're
way of
not being
knowing.
told.
We
Yeah, we're
have
not being
no.
told.
We have
Diligent,
no.
if it diligent, if it
We
was
have no. We have.
informal, if it was informal and he just walked by some TPUSA people, they wouldn't refer to it that way. They were saying that he met with the Turning Point individuals or team, et
That's what he
cetera.
said.
That's an official capacity of
Yeah.
some state.
But the term wasn't,
No,
Ian,
it
the term
doesn't. It
wasn't
doesn't mean
met.
that. That means he
Diligent
could.
will have to go back
It was
and
very
the two words,
specific.
No,
He
it could
didn't
yes, it
say.
mean
was.
I mean, he was
it could
Yes,
very
it
mean
was.
specific. He was
it could.
But
very
the two,
specific. He was. Oh, please, please. He was specific about meeting Chick-fil-A, right? So
Mhm.
he met TPUSA people that morning, right? Like that's
Right,
a
and I want to
fact.
hear
Oh,
more
according to the
detail
report.
about what that means specifically.
According to the
Like,
report.
does that mean they
Well, and
sat down and
that's
had
and the reason why we don't know is because the defense failed to ask.
well,
Career federal attorney, right? Career federal salary attorney failed to ask probably the most important question this morning, which
And it'll,
is who did he meet from TPUSA? Why did he meet them? How
and
long did he meet them? What
right.
was
So
said
and it'll
between
be
them?
it'll be really interesting to hear after that what they say the TPS, because TPS USA is now clearly in the back for Israel. So it'll be really interesting to
look at
see
that.
what they say. Are they going to try to impugn him more? Oh, he looks shifty, that sort of thing.
No, what I'm trying to say, Diligent, is did he go there and he's, one of the just another people attending, hey, I'm interested in starting a chapter at my university, or inquiring about merchandise, or inquiring about what's going on for the event? Or is he having some sort of more meaningful meeting? And until we have that testimony, which I'm surprised, like you said, I agree, it's something that should have been asked for in more detail. I'm assuming that to get more context from it, from the police officer, it would be considered hearsay, and maybe the defense wants to
Oh,
hold on.
this is
Wait, let
considered
me finish. Let me
hearsay.
finish.
Oh, this is
Let me finish
considered
what I'm.
hearsay.
No. Let me finish what I'm saying.
diligent, what I was asking you
Holy
is just to
shit!
go
Can't
back
people
and
just let
find the
someone
two
finish their
words
sentence?
that
Mitch,
they
you're
used.
now experiencing what it's like to converse with you, for what it's worth.
No, this is how Ian does when he doesn't have his mute button in control. He has like a freak out, needs to interrupt people.
What were
No,
you
the
But
two
saying?
words.
maybe very simply, the defense is holding on to that to subpoena for the trial various TPSA people, right, that are not automatically called as witnesses, to
You mean
get
the
that very
defense
information.
attorney? The
Yeah,
defense?
yeah.
She
Maybe there's
had
a
an
real strategic
she
reason why
had
she's
she
not
had
asking for more detail.
AJ watch for Baron Coleman down there. Bring him up if you will when she gets here,
I'm just suggesting, I'm not going to
or let
assume
me know and I'll
incompetence.
bring him up.
I'm not going to assume incompetence by the defense because if it's obvious to someone like you and me who are laymen, it's got to be obvious to her too. And I'm just assuming that there may be some legal strategy of why she
Listen,
waits.
why you would not take every opportunity to shed light on certain aspects that don't make sense to the public, even if
Because
it's
this is a
a
preliminary hearing, and there may
Having,
be a legal
honestly,
strategy of
so
making it
having,
a trial.
did you hear every opportunity was the key word there, Mitch. Every opportunity.
I think
No,
they don't want to
because
give their strategy away, though,
You have
Diligence.
limited airtime, right? You have limited airtime. There has not been a jury selected, so everything that's being said right now is being fed out to the public in the jury pool by the Fed sloppers, by TPUSA themselves, by the
I understand that,
government,
but this is a
right?
preliminary hearing to see if there is enough to move over to trial. This isn't
I
honestly,
about just
understand
proving the
that.
having
We
evidence, right?
understand that. I
having an
understand that.
Israeli
I,
shill like sitting here and obfuscating is
no,
just
I would.
insufferable.
Do we have a lawyer
I'm sorry,
here
you're
who may
just
have
here for
insight
Israel, dude.
into trial
I
strategy
mean, this
of
is
why
kind
you
of
would do
why
that?
we're all here because we know there's obfuscation on behalf of
You are not a
Israel,
lawyer. You
and
are
yet
very
you're here to
educated.
do it.
I'm asking
It's
for
just
someone who is a
insufferable.
lawyer. Like maybe I
Well,
forgot the guy's name.
we
Slick.
don't do echo chambers,
Maybe Slick
David.
Dog
I
can come
know.
up if he's around here. Someone like who's a lawyer.
I have Slick Dog blocked.
Oh, okay. Sorry. I'm just saying maybe there's someone who's a lawyer who has trial experience who can explain why the question that we all think is obvious
Baron
wouldn't
Coleman
be
said he's
asked.
Baron Coleman's an attorney, and he said he's gonna show up. So we'll see.
Okay. Well, I'd like
Can
to
we
hear
just
because
let
it's
Mitch
an
read all his
obvious
talking
question.
points to start the day, and then we can just have a conversation?
It's an obvious
Yeah,
question. I'd
yeah,
like to
Mitch.
hear
How
that.
about uninterrupted? Just read through all the script that you were given by Israel, and then real adults can converse. That'd be wonderful.
You're so pathetic. It's sad.
I think it's still pathetic to turn
You
this
went right
into
to
an
the ad hominem. Awesome.
anti-Israel,
I mean, it
pro-Israel
would be
event.
cool if we could just keep it
It's,
on. Keep it on.
yeah, just keep Israel out of it for now, please.
Agreed.
No,
Yeah. Let's
no,
stop talking like that.
that is
Please
ridiculous.
don't talk about the most obvious
Right,
aspect of all of these
right.
things.
Don't
No,
talk about the people we're not allowed to talk about. That sounds like TPUSA.
we're literally
Sorry,
talking about the trial. You want to go to
yeah.
your conspiracy shit? We could do that for another
Conspiracy
If
hour.
shit.
Israel is
But
brought
listen,
into
listen,
having been
listen, listen.
involved, then
No,
that's fine.
we have a few
Yeah,
hundred
it's
people
great.
listening
It's great.
on the spaces and on YouTube, and having it devolve into a like a meaningless back and forth about Israel without any substance is not conducive to
And it's
a good
Groundhog
show.
Day. It's like every day. So who wants to do that?
Well, I mean, the fact of the matter is that Israel had motive to take out Charlie Kirk, so it's not completely
No, they
moot,
didn't. I showed you why
right?
yesterday.
So it doesn't matter. It's a debatable
They
point.
clearly had motive. That's not even debatable. It may
They had
not doesn't
none.
make them guilty, but we can. And we asked Grok. They have like
And
I'm
massive
not.
Grok
I'm.
motive,
admitted it.
I'm not saying that they're guilty. I'm
right?
saying that they had motive.
Massive
And,
motive,
and
right?
they had no
And
motive.
by the way, AI confirms it. Like you,
No,
it's
AI
just
said the
data.
opposite, but you
Sorry.
guys lunatically interrupt the
So
AI.
AI lies. So
As
do you
soon as
think?
it said something you didn't like, you had to
So do you
interrupt it.
think that AI is
I
anti-Semitic?
just said I don't want to have this like
Whatever.
this tail chasing. I want to keep it on the trial if we can. Did anybody else take notes on what was said? Did I miss anything? So I posted about the car. That's huge, right? Does that mean that there's two vehicles there that have those distinctive rims? Remember, he knew that was Tyler Robinson's car because the rims were so distinctive. But here we are, and we have a report that there was a bald man and three other people in that car where the rings were so
Well, what it
distinctive.
could mean is a
So,
co-conspirator,
Mitch,
right?
don't
That's the
interrupt
bigger
me, bro.
issue.
Mute your mic. Don't
Well,
interrupt
I
me.
thought you were
I'm the
asking
host.
Jessica a question,
I
man.
wasn't done talking, Mitch. Mute your mic. Mute your mic. You'll know. You'll know. Everybody else knew because they weren't talking over me. So, if the driver was the driver driving a car that was very similar to Tyler Robinson's, which would mean that there's more than one vehicle that looks just like Tyler Robinson's at UVU that day? Well, that's interesting. Or does it mean that a different guy was driving Tyler Robinson's vehicle and there's at least four people involved with this murder or assassination, which would make it A, come with me, folks. If there are more than two people involved in a murder, what is it called?
Conspiracy.
Conspiracy! Yay! Let's go to Ian. Go ahead.
Well, this is. I'm going to point to something. You mentioned taking notes. One of the things that stood out to me, and I don't, I couldn't exactly follow the context in the moment, but the individual on the stand was talking about how there was this unutilized shell casing, right, that was ejected from a firearm, and they just kind of casually went over. Oh yeah, we found this other bullet. Yeah, it was ejected. Yeah, we don't know where it came from. No, I don't know whose bullet it was. No. I found that really bizarre, Diligent. So I'm curious if anybody else listened to that or has any theories on why that might be. It seems like something that's certainly noteworthy, and again, they just glossed over it.
Do
I
we
think
know
there's
what
Yeah.
kind of bullet it is? Do we know what kind of bullet it is?
Well,
it was a rifle
here's
casing.
No, no, no.
and
It
they
was a bullet, not unfired bullet.
it was a full bullet. She did ask if it was a 30-06 bullet, didn't she?
I don't remember.
She did, and
She
he said,
did.
"I don't
Yes,
remember."
she did.
It was very
And
bizarre. Yeah, he didn't know anything about it. He was
he
just like, "Yeah, we
doesn't
found a bullet."
remember. He doesn't remember. We found a bullet. And you know what else is funny is that they found a bullet. Was it on the roof?
They were talking about it as if it was. Yeah, they were like, "Yeah, we found this other bullet, but I don't know anything about it. We didn't look into it." It was like, how is this possible?
But how did they find a bullet on the roof but not a casing?
We
So
don't
let me
have
just get
clarity
this.
that we don't
Let,
have
let me
clarity
let
that
me
it was
get
on the
this
roof.
straight. Is the
Right.
narrative? Hold on. Is the narrative that he took a shot, picked up the casing, ditched the screwdriver, and ditched a full bullet,
Well,
and
bolt action
then
rifles don't eject bullets,
Are
right?
they
So it
are
was
they
still in the
saying that it
chamber.
was an actual like unfired bullet? I'm misunderstanding here.
it
No,
Yeah,
no, no,
doesn't.
yeah.
It,
diligent.
Basically, it would be like if you
it
had a
depends.
round
It
in the
depends on the
chamber.
type of bolt action. There's different
The
types.
rifle he had is not one that automatically ejects the bullet, and they found the casing in the gun itself with the writings on it. That
That's
is
not what we're talking, that's
That's
not what
not
we're
what
Diligent,
we're
talking
talking
about
about at
right
all.
now. That mission, that's not what we're
diligent,
talking about.
that
We're
is
talking
what
about a completely
Diligent was
separate
talking
bullet.
about, ladies and gentlemen. This is
diligent.
No,
You
But
it's
what
brought
that's
up
that
a
not.
going to
was.
good
be the.
point.
It's just going to be the mid show. I mean, I'm sorry, but that's.
Diligent
What
brought
about
up
the
a good point.
pistol that was in the holster that they, oh, I
Yeah,
forgot about
yeah,
that.
Sally, and also the fact the guy did not remember the 30-06, which the feds are saying is the absolute thing that killed him, and he didn't remember. It was I don't remember 30-06. Oh, I don't know.
It wasn't a
That's the thing.
pistol in a holster. It was just a
Did we ever
holster.
get any information around
A
the
discarded
actual
holster.
battery, the
No
camera
pistol.
battery for the body camera?
I was just gonna say that,
The
David, is that if that body camera was on, all of this other stuff that people don't remember would make sense. That's like the key part that I can't get over that he didn't have it on.
It also said on that diligent. I played around with Grok yesterday because I didn't have any knowledge about body camera batteries, and so I tried to basically utilize AI. Long story short, almost all of the ones used today have 12 to 13 hour battery times. It's essentially mandated by all local law enforcement officers that they go through a charging program or process, right? So the idea that this guy would have forgotten to do it or forgotten to put in all of that is be very, very against the routine that these guys are supposed to follow.
Bar-
And sorry,
Baron looked up on his podcast yesterday. I listened to it in my subscriber space. Um, the standard issue body cams for most law enforcement, he went through a few of them, is around 10 hours of footage so they can make it through a shift. 10
exactly.
hours.
And supposedly I don't know. So this should be looked into, but somebody suggested that this guy had only been on duty for something like 2 or 3 hours, if that, when this went down. So it would be like, oh, okay, you went
Yeah,
through
he
your
went on
10 hour
duty
battery in two
at
hours.
11.
And
Yeah,
I don't
he
even think they
testified
constantly
to that.
run their body camera.
It only turns on when they do
I only
that,
think
and
they use it when it's at applicable moments.
the body cameras record a minute in cycling, but then when you hit the button, it continues to record. So you always get a minute prior to the hitting of that button
But
to
it's,
turn
it's
it on
worth
for you.
noting, Mitch, the individual didn't say, oh, I forgot to press it. He said, oh, the battery died, which
Yeah,
is
yeah.
very
We all heard the
suspect.
testimony yesterday. Yeah, he
It's
testified to
just
that yesterday.
lying by omission, which is illegal under oath.
Yeah.
I feel like he just kind of straight up lied. He says that he assumes that, like, you either know or you don't. Like they have there should be data there. Again, this goes back to like having original footage. It doesn't
Dil-
make any sense to not know what happened there.
Diligent. There was the testimony about the people in the car. I wanted to go back to that car.
Go ahead.
Sorry, you're playing something. I want to go back to that what we were talking about earlier about the testimony or the hearsay testimony we have from the owners of the ring camera that they observed someone who was bald and other
Now
people in
there's
the car.
hearsay?
No, it is hearsay. The ring camera owner didn't testify. This is from.
Half of this is hearsay though, right?
Listen,
Like
it's not the point whether it's hearsay or not hearsay. My point is, do we know what time? Because apparently there was 4 times that the car was observed by this ring camera. 2 times was before the shooting. One obviously at the shooting, and one post. I believe that was the order. Do we know if it was before or after when the person
They said it
allegedly
was
who?
after, they said it was afterwards.
So afterwards was the person with the bald. Do we know
Correct.
which time it is? Because the reason I'm asking, I'll tell you why. If it's before, he's trying to just initially fit in. He's just going to sort of go and apparently make himself
With
look like he
three people
belongs
in the
there.
car, you're spinning a narrative right now. Stop
I
spinning
am,
a
I am.
narrative.
I'm suggesting a plausible explanation. I'm not
One
telling you
thing
anything.
diligent.
You're storytelling. You're
Yeah,
storytelling.
Yeah,
one
that
thing
is what we're doing here.
one thing diligent though
Wait,
on
let me
another
just
That's what
note.
finish my
you're
point
doing.
here.
That's what
As
you're
far as the
doing.
TPUSA thing though, the attorney should have at least asked, how do you know that? Right? So when you say he met with TPUSA, I would want to know what time did he do that and how do you know that?
So
That's
I'll play
100% true.
devil's
What
I'll
evidence do
play
you
I'll
have?
play I'll play devil's advocate. The only
Hmm.
reason I can think of that she would not ask that is because she doesn't want to implicate Tyler actually being there at that
Yeah.
time.
Well,
But still,
the
I
other
think
thing that's
asking how do you know that is still like a
right.
valid question.
Yeah, but the other thing that occurred to me along the lines that you're talking, because I was kind of like thinking in the way that you were just thinking, I was thinking, well, we know, like, the way that they would prove that out, another way would be by the testimony of people with Turning Point USA. And remember,
We
those
left
people
Okay,
are
okay,
all
we're back, we're back, we're
in the
back.
bag for Israel.
We're back.
Agent Hull was excused, and we are proceeding. Mr. McBride.
Yes, Your Honor. We intend to call Jennifer Falmuina, but before I do that, I'd
Who?
move the admission of State's Exhibit 5.1.
Someone
if I
named
can approach
Jennifer.
the bench.
Jennifer Paolina.
Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
All right. Let me just. Do you wish to identify what State's Exhibit 5.1 is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Engelhardt from Turning Point USA.
All right.
And yeah, again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4. But the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor. Thank you, Mr. McBride. So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person, so it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak. As you're, and again, I appreciate your discretion in highlighting that point. Do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument, or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public,
of course,
our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance, and if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3, paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll
New
just refer
new
to
update up
generically
in
as
the
goals and
jumbotron. Up in the
objectives of
jumbotron.
Turning
New
Point
clip.
USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is, and I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence, and there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Engelhardt's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information, that is the document which lays out the allegations against Mr. Robinson, when I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
Thank you. And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on two things. One is, whose state of mind are we talking about? Or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Engelhardt describes as traditional Orthodox Christian values that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that the 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Englehart's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here, in this proceeding, what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks, and again, I say this with all due respect to Mr. Engelhardt, who I've never met, the book of Matthew means, or how one reconciles the book of Matthew as he sees it with other views on
What is happening right
the
now?
topics
Get this
that are
guy
there.
off
I mean,
the
I wanna be
podium.
careful and not suggest what other views are, because I shouldn't be testifying about different perspectives within the sort of the heading of religion. But it doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. That's your honor. There is nothing in this that helps the court resolve, with respect to the victim targeting enhancement, whether Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's beliefs or perceptions regarding Mr. Kirk's political expression. If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court, because the court has to decide whether there is evidence of the target enhancement in the way I think I've structured it. So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly, and one of which I think is appropriately discussed at sidebar, because it does get into undue prejudice. The 403 here is that receiving this document into evidence is going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Engelhardt's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about, is going to create significant confusion. And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that.
This
may
is
be
Tyler
important in some
Robinson's
other
attorney.
context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court
Bottom right
is going
corner,
to
please repost
suggest
the space,
to the jury
everybody. Thank
pool
you so much.
that this is a case about religion. This is not a case about religion.
We have
The state doesn't
400,
even allege
400
this is a case
listeners
about
and
religion. The state
99
alleges
reposts.
One
Please repost
enhancement
the space.
based
Thank you.
on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a, sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state wants to proffer Mr. Engelhardt for some specific evidentiary purpose that I'm missing, then we can engage in that. But it seems to me that it's, again, a mixture of lay and expert opinion, which at this stage is more prejudicial than probative. The other part of the 403 issue we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak. Turning to the state. And so just to give an overview.
Thank
what
God,
I'm
that
intending
was-
to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in
That's the court
debate,
reporter. I don't know
discussion of
why her
traditional
mic is
family
on.
values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically and attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible. because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Oh.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible.
Okay.
I understand that the court has two roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and to their right to fairness, requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly, saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear, does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to constrain you from saying, well, I don't know what you're going to say, but
Yeah.
I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride. In regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, after the court rules on that, I will make my full argument.
All right, well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your client, and every attorney should be doing that, that is your duty, I don't want, if you feel that closing this hearing to the public is necessary in order for you to fulfill your duty, the court will entertain that. But I can't have it both ways. If you want me to close the hearing in order for you to be fully, be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument to best represent your client?
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make a closure ruling, I'd like to be heard before you do.
All right, I'll hear from you as well. If you would like to come forward, again, just, Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure, thank you, Your Honor.
They're
David
arguing.
Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this, and that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis to close the hearing. There may be a 403 argument. I haven't seen this document. I don't know what's in it. Maybe there is something incredibly prejudicial. You would have to make that decision. I'm at a loss. I haven't seen it. I'm happy to take a look at it and give you substantive argument, but it's the same high constitutional standard that you have to satisfy in order to close it. And then the last thing is just on the scope of any closure. Kearns Tribune speaks, and I know the court is aware of this. If you are going to close it, it needs to be as minimal as possible. And it's my experience, at least, that most of the argument about things in this context can occur in open court. And if you want to have, a closed session or a sidebar or however, you have also done it in chambers, I just ask that it be as limited as possible. Thank you.
Thank you. All right, Mr. Novak, and it appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta, 857 P. 2nd 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits, that was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential future evidence that the court may receive in this hearing, or it may not. So I'm not going to address other 403 issues in open court. If the court wants to defer this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment, it's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding eliminates the need, from our perspective, for that 403 issue to be discussed at sidebar, or at what counsel for the media says in a closed proceeding. However, I agree with the court that Mr. McBride can't have his cake and eat it too. If he wants to make his argument and he thinks that his argument requires that he read an exhibit in court, which we in good faith are saying is not admissible, then we need to have a closed proceeding. I'm not asking for a closed proceeding. I was asking the court to caution Mr. McBride not to read into evidence exhibits that are not received into evidence, because that's the same as Mr. McBride testifying.
All right. Thank you. Anything further, Mr. McBride?
Just a note, I have not made my full argument on admissibility, that's all.
All right. All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder, and whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different, the standards are different, and different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information, going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything. But what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement, in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so, if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds, but at this point, the court finds it is relevant for consideration, and for at the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service and the type of business. And so there is grounds for that to occur in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Thank you. 5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. that's in paragraph 3, that these events discussed political issues as well as religious issues.
My bad.
Those political issues in the portion I previously quoted talked about gender issues in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And that information is relevant to the motive that we are alleging in this case. And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and that he falls into some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses, that talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder. Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here, but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind, and that's what motive is, and that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information alleges, which is the allegation is that Mr. Robinson perceived that Mr. Kirk had certain political views, that's one thing. But this document talks, and now Mr. McBride, not to be colloquial, has sort of thrown down the gauntlet. This document talks about foreign affairs, political doctrines, America's founding principles, cultural trends, and what Mr. Engelhardt refers to as Orthodox Christian views on sexuality, marriage, and gender/sex. So this document goes way beyond what the state just flagged for the entire world is their view of Mr. Robinson's motive, which has something to do with gender identity, gender ideology, and sexuality. That's what Mr. McBride has just said this case is all about. This document goes way beyond that, and that's why it's not admissible. There may, as I said, be other evidence which Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's relevant in the sense of has a tendency to make a fact of consequence more or less true. That's the definition of relevance. So how does this court go from what the state has to establish, which is motive, or well, actually, the state doesn't have to establish motive. Motive is not an element of the offense. But at least with respect to the victim enhancement, according to the legislature, the question is, what is in Mr. Robinson's state of mind? The other thing I want to say is that Mr. McBride did not address the admissibility of these opinions. Now, the court talked about 1102, but 1102 doesn't resolve all of the other rules of evidence. It's just a gateway for an affidavit. So what we have in this document are what I think are purport to be untested expert opinions or at least lay opinions. And the question is, under the rules of evidence, is whether this document is helpful to the court when it makes a determination about whether Mr. Robinson perceived that Mr. Kirk had certain political views. So where is the evidence that Mr. Robinson, in this document, that Mr. Robinson was aware of Mr. Kirk's political views? Where is the evidence in this document that Mr. Robinson had disagreement with Mr. Kirk's political expression? None of that appears in this document. There may be other evidence of that we'll have to see. But there's nothing in this document which connects up with Mr. Robinson's state of mind, which is the question in the enhancement. And Mr. Engelhardt cannot, of course, express any opinion about Mr. Robinson's state of mind because he doesn't know him, and because that would be improper opinion evidence under any rule of law. So for a document to be received into evidence that quotes one very narrow piece of religious doctrine and that involves Mr. Engelhardt's interpretation of what that means. I mean, Mr. Engelhardt at the top of page 2 is basically telling this court what he thinks Chapter 19 means. How could that possibly be admissible in this proceeding? And how could it possibly be admissible for the purpose of this court concluding what Mr. Kirk thought Chapter 19 of Matthew means? So it's not relevant. It's improper opinion evidence. It's definitely overbroad in terms of the evidence that the state is proffering to prove a very narrow point, and it actually doesn't get to that point, which is what was Mr. Robinson's state of mind. It also doesn't say anything that Mr. Kirk specifically said on September 10th that Mr. Robinson may or may not have heard, or anything that Mr. Kirk said before September 10th, specifically, that Mr. Robinson may or may not have heard. Nor has the state presented any evidence, and as an officer of the court, I would say I don't think the state can present any evidence that Mr. Robinson specifically heard Mr. Kirk say a specific thing at a specific time. There are some statements which I think that the state will say are admissions by Mr. Robinson, which reference Mr. Kirk, which we will get to later, but none of those reference specific statements by Mr. Robinson about specific statements by Mr. Kirk on any specific issue that would even make a piece of this relevant. So I'm pretty sure that I've reached that point where anything more I say, I'm going to be repeating myself, and so I'm just going to stop unless the court has questions.
I don't. Thank you. Well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes.
Okay. All right.
Because I don't want to be the expert. I mean, the court's basically asking me to testify. I'm not trying to be flippant. The court is asking me to testify about where religion and politics intersect. And that's a fascinating question. The question here is whether this document, the way it's presented, the way it was written, is admissible under relevance and expert 701, 702 rules of evidence to prove what Mr. McBride says the state, what he acknowledges the state has to prove, which is that Mr. Robinson had a state of mind which was, let's just say, hostile to Mr. Kirk's political expression. And I don't think that this court should be deciding, based on the record before it, where, if at all, politics and religion intersect. That's. I mean, if the court needs to resolve that issue, then the court also needs to resolve the question of which religious philosophy are we talking about?
Well, Mr. Novak, I bring that up because you mentioned it, and you said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into place. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt.
Sure.
I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument.
That was brutal.
Advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant, what is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression, and the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point when it becomes relevant based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, let us proceed to lunch because it is now 12:40. It seems like a natural place to stop. I believe everyone looks like they need a lunch break. So let's go ahead and break for lunch. Let's come back at 1:15. Well, I need to give you a full lunch here. I need to do my lawyer math and see what that would bring us to. So it's 12:40. Let's come back at 1:45 for lunch. All right. Any party need the benefit of the record before we break for lunch?
Not from the state, Judge.
No, Your Honor.
All right. Court is in recess until 1:45.
All right. Ooh, that last part was brutal, man. Oh, that was rough. That was
I actually love
awful.
it. That's my
You
favorite
you
part.
you love the court slop, right? Can we call it court slop?
I love the arguing. I love arguing of law. That's why I like trials. So
You brought up a good point in the chat that the reason why this is relevant is because the jury pool in Utah is Mormon, right? And the enhancement that they're using to make the murder charge aggravated and give Tyler Robinson the death penalty is based on political ideology and not religious ideology. So if the prosecution is allowed to bring in the Bible, right, it will sway jurors who are Mormon against Tyler Robinson, right? That's what the defense is arguing here, and it actually makes sense. The enhancement is not a religious enhancement, it's a political enhancement. So therefore, they should not be allowed to bring religion into it unless they want to change the charges or have a charge where the enhancement is based on religious discrimination or hate,
But we all
right?
recognize in today's world where the boundary between religion and politics lies is a very fine line, right?
well, in the United States, it
I mean,
shouldn't be.
maybe for you, Mitch, but not for me.
What do you mean? How many
Yeah,
political
maybe in the
arguments?
Talmud, but not in the Bible. No.
Hilarious, the man who quotes religion all
Yeah.
the time. But
I
Hmm.
point
mean,
to the matter,
I've read a
but
significant portion of
diligent.
the
The point
Bible.
is,
I've read a significant portion of the Bible, and never one time did it say Democrat or Republican.
no, obviously, but how many political arguments that are in the sphere of influence politically
but
are
Diligent, I heard it.
sourced in biblical ideas, for
But
example,
Diligent, that
LGBTQ ideas.
I heard it the opposite though. The fact that the attorney spent so much time trying to build motive. I mean, the lack of evidence. How little time that they need to put the gun on the roof. There's so many. Sam Parker put out a great post about this. They need to put the lack of evidence, how little put the gun on the little time that they there's need so to many put the gun Sam on Parker the roof. Put out a great there's post so many this. Sam Parker they need to put out a great put the gun with this. Tyler anywhere they on need to campus. Put it like there's so put the many gun with Tyler anywhere on campus. Like there's so many physical with it in the OJ. This invites the conversation
They
about.
definitely have
Hold on, hold
established
on,
him
hold
on
on, hold on. This
campus.
invites the conversation about the motive for Israel because the motive that he was building for Tyler Robinson, it was actually kind of flimsy. And I mean, I understood it. He was saying, well, he has this kind of thing and he's trans and, doesn't like, I mean, it's really kind of like, okay, so that's it. Like, obviously there's lots of trans people that don't like Charlie Kirk, but they're saying, and so that's the motive. But then you could turn around, of course, and they should do this. I think if they don't, the fix is in. I think that if they don't, given what Joe Kent has said, if they don't go, well, here's a country who can't survive without Charlie Kirk's constituency supporting him because everybody else has left him. This is the one. And that country can't survive, and they can actually show a lot more motive. So it'd be interesting to see because I feel like not enough primary evidence here, not enough physical. They got away from the physical evidence way too quickly. What do you think about that? This is the one. And that country can't survive, and they can actually show a lot more motive. So it'd be interesting to see because I feel like not enough primary evidence here, not enough physical. They got away from the physical evidence way too quickly. What do you think about that?
I think that
They'll
they have
go into more
established very
physical
well that he was
evidence.
on campus. I think
No,
they
they
very
have,
well
Mitch, they
established.
haven't tied it to being him, though. They have a
Yes, they have
person
so
there.
far. This
Yeah, I
testimony
mean,
from
and when they're
police
saying
officer.
early on when they
When
were
you have
saying
one
they were
second,
having they were getting so
testimony by
nuanced
a
about
police
like,
officer.
oh, so he walked up the stairs. Does that look like him? Does that look like who do you think
So
that is?
so
It's
so
just hold on. I wasn't talking to you. I was talking to her. So it just looks so weird. I just expected them to you would think that they would put their best foot forward. And if they're saying this is their best foot, they're not saying, well, this is how we know he had the gun. This is how we know he pulled the shot. This is where he was. This is the residue on his hands. All physical things. Physical evidence. I mean, I don't, it's just almost like, do we have a case here at all?
Well, what the whole
well,
point of
so
that
we
was,
have established very
hold on,
clearly.
Well, go ahead,
Mitch. Hold
Sally.
on, Mitch. This is not the Mitch hour. We're trying to have an adult
I haven't
conversation
said
here.
anything for hours. I've always said it's the
Yeah,
Mitch
for
hour,
hours,
not a
you were
room.
just interrupting David. Like, seriously, let other people have a conversation
Respectfully,
because
I was talking and David interrupted me. But
respectfully,
please
I
go
want to
ahead,
answer
Sally.
David. I want to respond to
Let's
something.
let
That
the
whole,
woman chime in, you bigots.
thank you. Gosh, such misogyny in this room right now. No, the whole point of that lawyer and everything he was doing, he's trying to get the death penalty off of the charges. That's what he's trying to do right now. They made an announcement about that. They were going to try to do that today.
Which
So
which and just strategically it makes sense, right? Tyler Robinson is less likely to take a plea deal if the death penalty's off the table. So they have a stronger case to actually fight in trial than to have him take a plea deal.
What is
Hey,
the,
Absolutely used as a
Billy,
bargaining chip.
just to butt in real quick. David, sorry, bub. Just to butt in
go
real
ahead.
quick, Billy. If you could keep your mic muted because I'm getting so much feedback, and it's only whenever your mic is unmuted. It's an
are you on
echo
an
chamber,
Android,
brother.
Ronald? Are you on an Android?
Absolutely,
Yeah, that's
Yeah,
absolutely.
it. That's a you
it's because
problem.
you're on a
Is that it?
video. It's because you're on a
I've been
video
wondering the
space.
whole time because
The rest of
the
us are not getting that feedback. No.
yeah the past 2 days I've been trying to get on
Yeah,
the spaces and stuff.
you'll have to get on the desktop version on your browser and then
You also might want to check if you're using noise reduction earphones. That is a matter. You may want to turn off the noise reduction, noise isolation feature. I've been told that that is a factor too.
Yeah, I only notice it whenever Dilly has his mic unmuted, and then the rest of you start echoing. But only Diligent to me is echoing in
Yeah,
this
I
thing.
don't want to have this
It's a you.
this
It's a
whole.
you issue.
I
Then
want
it's
to
not the
bring it
rest of
back.
us.
I want to bring it back to the trial. Thank you. Thank
Well,
you. Thank
Diligent,
you.
I have a question for
So
you.
can I just go to the
Did they
question
did
that you
they
say
bring
what's been
up the
established?
1 second? Did they bring up the note though, Diligent? I mean, isn't the prosecuting team supposed to be presenting all of their evidence, like what they're submitting, and did they bring up the note?
You're
Suppose
not actually submitting all
I'm
of the
asking
evidence yet.
Diligent a question here, please. Did they bring up
I
the?
haven't heard them do that yet. It was
Yeah, I
brought up
didn't hear.
once yesterday, I think.
Yeah, I didn't hear anything about the supposed confession note, and I'll be interested to see if that comes up and then how they present that.
So in terms of, you were saying that things haven't been established yet factually. They're arguing an enhancement issue, which
Still
I'm
going.
kind of confused why they're
You
arguing
know,
it now, because this is for trial. You're not going to be enhanced or not enhanced just at the preliminary hearing, but that's a separate issue. But
just out of curiosity, Mitch, are you paid to be here?
we have
Are you paid to
established.
be here, Mitch? Is Israel paying you?
Do you interrupt everybody? Is this how you
No,
deal
I'm
with
just
everybody in
asking
the
you a
room?
question. I won't
Okay,
interrupt
I'm
you.
really not interested. I'm really just saying what I'm saying. Please just stop.
You can
Thank
answer.
you.
I think it's important. I think it's important that we have a serious discussion about, like, you know what's interesting is I wonder if the prosecutors are Mormon. Did anybody look into that?
Why would that be relevant? What is the relevancy of whether they're Mormon or not?
Because they have what?
It's very relevant. It's very, very relevant. What are you talking about, dude?
It's in Utah.
No, I'm just asking, what is the relevancy? I'm not a Mormon. I don't know Mormonism, so I'm asking seriously, like, why does that
How many
matter whether
times
you're
have you
Mormon or not
heard a
if you're a prosecutor?
prosecutor
If
quote the Bible?
listen,
Matthew
don't you
19
think?
Resident Mormon
says,
here.
Let
Resident
me
Mormon
answer.
here.
Let me answer the question. If this was you have a hot mic, Mitch, and it's loud. Um, if Tyler Robinson had shot a rabbi and the prosecutors and the judge were all Jewish, don't you think that would create bias against Tyler Robinson?
In my opinion, if you're a legal professional, you're a legal
Oh
professional. But
my
I guess you feel
God.
like
Oh
religion
my
is a
God.
part of
Can
the
you
profession.
ever just be real for just 2
I'm
Diligence.
giving
seconds?
you my
He's
legitimate opinion. You
noticing.
don't
It's
like it, you don't like it.
intensifying.
It's kind of cute. I'm not gonna lie.
But
No,
this
it's
isn't,
not. It's so
I'm trying to
obnoxious and
understand for
predictable.
trial, why is a Mormon
You
issue? This
hesitated
is a
because you
Christian man.
know that it will create bias, bro.
No, honestly, is
You're
Tyler
being
Robinson a Mormon?
you're
I don't
not being in good
understand.
faith here.
Is he a Mormon?
Yes.
Is Tyler Robinson a Mormon?
Yes.
Okay. So can I just get
But
back to the
more
facts that we were talking
importantly,
about? Because someone said we had not established facts.
are the prosecutors Mormon? Because Tyler is
Well, I looked that up.
according to the FedSlop narrative, Tyler abandoned his faith and embraced the furries, right? That's why it's
I
important
looked it
here.
up, and they basically, not only could I not find it, but they kind of say that prosecutors tend to not share that information about themselves, like in any case, whatever religion, which kind of makes sense, right? I mean, you know.
Grok, are you there? Can you hear us?
Yes, I'm here, loud and clear. How's
I can hear
it
Grok, but
going?
Grok can't hear me. Let me try it again. I want to know because it would create bias. You know what I mean? Like, why is he bringing religion into it if the enhancement is political? You know, but he did that on purpose. Is that because he's religious? You know, it's a Grok. Can you hear us? I don't know. I give up. I quit.
Can I at least go back to the fact
Have you
issue?
done
Like
that one time
whether
in any
you,
of my spaces?
I'm doing that right now. Like people say we haven't established that he was on campus. We have testimony from police officers that their video shows he's on campus.
Meeting with
Testimony that
TPUSA.
someone was.
Did you see that
Pardon?
footage? Can you clearly identify?
I just didn't hear what you just said.
Did
Blanked. What
you
did you say? Something about
did,
TPUSA.
can you guys hear me?
We can. Mitch just
Now I
We
can.
doesn't
can.
You
I
hear.
can
blanked
hear
for a
you.
second. I didn't
Yes.
hear what you fully said.
He
What did you
doesn't
say?
stop talking long enough to hear you.
So Mitch, did you were you able, in any of the images or video presented to us thus far, can you honestly say, and I mean honestly, like God is about to judge you if you lie, right? Final judgment. I don't know if Jews believe in that, but let's just say that you do.
They don't.
Okay.
He's allowed to
So
lie.
let's just say, right? Have you seen an image or a video in the last 2 days where you could clearly identify Tyler Robinson?
So to be frank, and while I've been in your spaces, when I'm on panel, I cannot see the Jumbotron video. So I've been solely paying attention and taking notes on the testimony of those on the stand. And the testimony is what is relevant
So you're
because
dodging. You're
sworn
dodging.
testimony is evidence. I'm not. I'm giving you what, to me, is evidence. The sworn statement of someone on the stand is evidence. That's the legal definition of evidence. And the evidence we have is the
The
testimony
reason
of
why
those on the
this is an
stand that
important question is because if you can't and I can't easily identify or conclusively identify Tyler Robinson from those images, then it's fair to say the officer probably can't conclusively identify.
even if you believe that, they testified that they did, and therefore that is evidence
No one
in the
ever
record,
lies. No one ever lies.
Yeah,
that is
because they
how the
wouldn't lie.
decider of fact makes his decision.
Oh my God.
Well, Mitch, what do you think about that
But
saying, believe
listen,
none
the
of what
judge
you
is
hear
going
and
to
half of
decide
what you
on
see?
Well, and I will tell you
based
this, it
upon.
doesn't actually work that way because they could show that video just to the jury and just ask them if they can tell, right? So this is really just about, I mean, you don't need to listen to the officer go, yeah, that's him when you have I mean, they see the defendant sitting right there, right? So
Well,
the
David,
jury,
that's why they're trying to get the enhanced video in there with the
yeah,
AI to sway the jury.
yeah. I'll tell you something, Sally, when your grok is back up, I would like to hear what physical evidence we know now that they have presented. I just want to hear, forget them saying, well, he's guilty because he's mad because he was a furry or something. I just want to hear them say, well, we found this. I mean, because I hear separate things where Tyler Robinson either isn't present or where they're referring to Tyler Robinson where there's no gun present. But I haven't heard where they're putting the gun in his hand and him pulling the trigger. This is just so. Are you not having this disconnect? I'm just really like, okay,
They don't have evidence that that gun, they don't even have evidence that the person on the roof shot the gun.
Oh, we're getting there. We're going to get there. Oh yeah, we're going to get there, Dilly.
why? How do you know
Because
that?
we have timing, we have place, and we have manner. Okay, so they got
There's
his
solid
car
evidence
at the
linking
scene.
Thomas Matthews
He was pulled
Crux
over
to
by
the
a cop.
shots from
They
the
ran
roof.
his
Multiple
license.
witnesses
It
saw
was
him on
his
the
car.
MGR building roof
They have
with a
somebody.
rangefinder earlier.
I will grant you.
Then
If
climbing
I
up
knew
and moving
Tyler
across it.
and I knew
A
his
local
picture,
cop got
I'm
hoisted
like,
up,
man, it
locked
looks
eyes
like
with
him,
him,
but
and
well,
Crooks
there's a
aimed a long
reasonable
gun
doubt
right
that
at
that
the
might
officer.
not be him.
Body cam
But it's
caught the
damn
cop now.
close,
He's
okay?
got a long
But now
gun
we're going to
and
get to
hauling 8 feet
DNA
when he
evidence.
let go.
So we're going to
Forensics ties it
place him
together.
at the scene, dude.
8.223
The dude is
cartridge
cooked.
casings were
Wait,
found right
wait,
by
Back
his
Eddie, is
on
body
the
that what
on the
this
fence,
roof.
gotta do
Eddie
something.
Eddie
Ballistics
Eddie is
matched
that what the
bullet
You
jacket
guys are
and
enhanced
getting
fragments
into
of a
what
video?
you
scene
perceive.
Hold on,
evidence
But
Mitch.
you,
Hold on, Mitch. This is a valid a question for this conversation. Quit trying to divert it. Eddie, is that with looking at the enhanced video that was presented, or is that with before that?
Well, I was trying to pace. I was zooming in. I went to YouTube on Billy's YouTube so I could zoom in and I could focus in on it. I mean, it looks like him, but I could not. If you just gave me that picture in a lineup, I'd be like, I don't know, man. You know, I wouldn't be able to do that. But
okay,
if you
so
give me his
Eddie,
car and you give me other circumstantial evidence,
yes,
man, dude, if
exactly.
I'm
okay,
a
If you're
juror,
bringing in
dude,
walk me
circumstantial
through that though,
evidence,
Eddie. So you said
it
this
is.
car is there, and then what's the next thing, Eddie, after the car?
you're gonna have to repeat that, man. It's bad reverb in here.
I'm sorry about that. So I was asking, you said that his car, so you're saying his car was on premise at that time, is that right?
Yes.
Okay, now what's the next piece of evidence that kind of does it for you?
Well, they're following his footsteps, right? Or this individual that I'm 80% there that it's Tyler, right? I can't get a super clear picture.
So they're following this individual, leaving, coming back, parking his car off campus, having this weird walk like he's got a gun in his damn pants. They're tracking him all the way through. Now, what I'm saying is tomorrow we're going to get to more physical evidence, such as DNA, things like that. And then I don't know how you are going to spin that, but
you know,
it's
Eddie,
looking
just one
very bad.
comment.
So you mean
Eddie,
DNA on
Eddie, it
DNA
doesn't
on the
matter.
gun?
It doesn't matter what we perceive the video. The expert testifier is the evidence, and that expert testifier said
No,
that is I, an expert, have
no, it's
identified
not
in that
true.
video
He's not an
Tyler
expert
Robinson.
seer. Do you understand? That's not what expertise is. That's incorrect.
Yes, he is a
Everybody
police
sees the
officer.
same. He's not like I have
Okay, the
special
very
eyes.
Does David do
expertise
this
that you guys are,
nonstop? For
wait a
God's
minute, Eddie,
sakes.
wait. The very expertise that you guys are saying is an expert, okay, couldn't remember that if the gun was a 30-06, okay, couldn't remember
Right,
that. Couldn't
right.
remember, by the way, this gun that they keep talking about and
The
these bullet
pistol and the pistol
fragments
holster? The pistol
and
and the pistol holster?
these bullet fragments and all this reference to ballistics, okay, never gets, all these little pieces never seem to be able to be put together.
But
They
we
don't
haven't
have.
gotten to the bullet identification
Yeah,
yet in the
but you
testimony.
know,
No,
you're
I
That's
know,
not
but
yet
yeah,
I'm
in the
they,
And
record.
Miss
but
Lou,
he
I
doesn't
wasn't
even remember, David. He doesn't even
sorry.
remember that it was the 30-06, and this is one of the key investigators.
Yeah, and Miss Lou,
But
So
he has
my
done
my
the
point my
significant,
point to you,
David,
Miss
you don't
Lou.
have to
No,
just
hold on one
speak
second.
anytime I
My
speak
point to
just to
you,
be
Miss
this.
Lou.
Can we
I'm just
mute
I'm
Mick
showing.
for just 3 seconds so we
I
can
am
have a back and
I
forth
literally, every
I
conversation?
am
time I talk, he
responding to
just
Miss
mumbles along,
Lou
over
because
talking me, and you guys
right,
are
I'm
allowing this.
responding
can
to
I
Miss
hear
Lou.
No, you're not
David,
Just
responding.
please?
right.
For the
You're
Can
record,
yes.
I hear David?
for the record, I just want to throw this out there. AJ has looked it up. It does look like the prosecutor is Mormon. So good job, AJ, or at least very religious. More on that later.
Okay, I'd like
Okay,
to
just
hear
to get
what
back, just
David
one
has.
second. But I was in the middle of speaking, so do you mind, Miss Lou? Because I've been overtalked
No,
nonstop. I'm not
I'm
even being
responding to
difficult.
Miss Lou. Okay,
You're not.
I'm
No.
doing
You
this for
literally
free.
were
You're getting
Can we
overtalking me while I
please
was saying
mute
$7,000. Okay,
Mitch
before,
or
and
put
then
him
you
in
strapped me
so
here.
timeout?
right. So
Well,
Miss
what?
Lou,
Miss
I don't
Miss
understand. I was in the
Lou,
middle
Miss
of
Lou,
speaking to him.
you just lost $7,000.
yeah, right.
Great,
So
but I was in the middle of
I
speaking, and then
Just
he
I am
stop,
overtalked me,
responding to
Mitch.
Miss
and then we
Lou.
distract the
Listen, I'm
Mitch,
conversation
sorry.
here.
Will you stop with the misogyny? Why are you talking over all these
What
women like
misogyny?
that?
Yeah,
David is not a
yeah.
woman. What are you
I'm
talking about?
You're
asking Miss
talking.
Lou
Miss Lou
questions.
is asking
It's his
Miss
Jewish schizophrenia and
Miss.
I
Right,
understand.
no.
But this
Disavow,
whole thing starts
disavow,
because
Right.
David
disavow.
has to overtalk every time
So
I
my
speak.
question,
David was asked.
I was talking
David and Miss
calmly.
Lou.
right,
David and Miss
and
Lou are having a back and forth.
and
That
it's a
Let them
ruins
simple
have
every
their back
question
and
space.
too,
It
by
forth.
the
doesn't matter
way.
if we're talking about ping
Right.
pong
And
or
unlike
anything
you, it's not like a
relevant.
Can we
long
put
time.
him in
Mitch,
timeout for 5 minutes,
Mitch, please
please?
Yeah,
don't make me drop you for a minute,
yeah,
please.
please.
You
They
got to be
all want
kidding
me
me.
to.
Yes, please. So Miss
Literally,
Lou,
David just does this every time.
so my question for you, Miss Lewis, I'm not even dismissing what the officer has to say as far as his observation. It's just that it would seem like an obvious question in the court. Okay, like the jury, all of us can see a video exactly the same way. So it's like back what Diligent said, can you really say, the rest of us, do you have some special information when you look at this video that makes you sort of irrevocably conclude that's Tyler Robinson? Because the rest of us look at it and we can't really tell that. So I'm not really dismissing what the officer is saying. I'm just saying, look, I have the same eyes that you do, so how is it that you are so certain, given the rest of us just kind of see a guy? Does that make sense to you, Miss Lou?
Well, yes, it does make sense insofar as you're not dismissing, but I keep questioning. It's like I can't get it together in my head that what we're really listening to are people who are being straight up. It's like nobody brings up the fact to point out the bald guy with the car, not mentioned at all, even though the car was mentioned in the rain
Where was
cam.
Blake Neff on the
And
nights of 9
yeah,
10? I'm curious. I'm
I mean,
curious.
it's just the past 2 days. It's just been constant. Well, what about this? Well, what about this? And if we're sitting here doing that, what the hell is a jury gonna do if they can't get the straight facts? They're
So
gonna be.
so if you ever visit Utah and you talk to the Mormon crowd, right? They are not dissenters, right? Some of them are, but the majority of them do not question things, right? Tyler Robinson being the lover of a furry and taking out Charlie Kirk is easy for them to accept, right? So that's the play here, right? That's a narrative that's easy for them to accept. Not they're not most of them, not all. Hashtag not all. Shout out Hitch Slap. They are not all. Many of them are not going to question that deeply, right? They're going to want to get this over with. They're going to go back home. They're not going to want to be a part of the circus. And the prosecution knows that, right? The fact that they're trying to inject religion into this publicly already shows you that they know that. They are strategically trying to place it in the minds of potential jurors that this is an evil satanic boy, right? And that they're up against evil, and their godly duty is to make sure that he sees justice, right? That's the play here. So
It's
that's my
almost,
But
it's
opinion.
almost
diligent,
like Utah was
but
chosen for that reason.
diligent.
Resident Utah.
Utah was chosen.
I think Utah was chosen for a number of reasons, particularly this one. This is a very rare the burden of evidence,
What do
the
you mean it
burden
was
of
chosen? This is where the crime took place.
excuse
What
me.
does that even mean?
The burden, let me finish
He's
what I
trying
was
to
saying.
explain it, Mitch.
Yeah. If you shut up, you would know. So the burden of proof for the preliminary hearing is much lighter than it is in a lot of other states. It's almost unique in this way, right?
Well, what's
So
the burden?
hearsay is acceptable, which is
Well,
pretty
because
uncommon.
it's set up. Yeah, they just have to show probable cause, right?
Well,
They have to
can I
show that a
explain? So
No,
there's
crime took
no,
two.
no,
place.
no, no, no. Hearsay evidence can be used to prove to justify probable cause, right? In a
Yeah, I
lot of
understand, but
states,
the standards of evidence are different than at a trial.
You have to prove that
They're
a
also
but
crime has
different in
occurred.
Utah.
even with that being said, Utah is very very uncommon, at least in this way, right?
They're
But
sheep.
you just have to
Hold on,
prove that a
Mitch. Hold on. I'm from Utah. I've been born and raised in this state. I know how the culture is. And
Let the
diligent.
Mormon speak. Let the Mormon woman speak,
Thank
Mitch. Let
you.
her speak, Mitch. Let her speak.
You're not even talking.
Well, whoever was talking, please just let me talk real quick. Diligence 100% correct. They're sheeple. And then you have people like Mike Lee advocating for the death penalty without there even being a trial, a probable cause hearing, or any of that stuff. Today, I had a client here and I was listening to Diligence Space out loud. And she's like, well, what about this? And what about that? Well, didn't he do it? Well, what about Erica? And so she had all these questions that she was not asking. And listening to the hearing today and listening to diligent other people speak, she's like, oh, maybe he didn't do it right. But the assumption is he did it. Our legislatures, like Mike Lee, are pushing this narrative that he did do it and he should get the death penalty, which is muddying the pool even more, especially when you have a state full of sheep that just go along to get along. They turn the other cheek. They accept Muslims. They accept everyone in this state and in this culture. And so Diligent is 100% spot on.
But AJ, wait, just one thing. First of all, the preliminary hearing just established that
Wasn't
a
AJ.
crime occurred, and not that oh god, and not specifically that he has done it, but he is the most likely person to have done it. And so
No, he's
far, what do we
not.
have? So
What
far,
about
what do we
Last
have?
Twigs? What
So
about
far,
Last
what do we?
Twigs? He
So
could have done it.
Most likely
please,
is
please,
not is not
is it a
the
fetish to
death
overtalk every
penalty
time I say 5
qualification.
words? Like, is this just a game here?
No,
Like
you just
diligent
had your
every
talking points
time.
Most
and we're sick
likely,
of
hold
it.
on, I need to see if the video is lined up. So just
Let
stop
me just
talking
finish
for a
what I'm
moment.
saying so I can run to
Shut your
Candy Crush,
mouth,
for God's
bro.
sake.
Let me, I'm trying to get the video lined up for the space. Can you guys see it on your screens? I want to make sure that oh, okay, I just got an interesting text. Sorry, Mitch. Oh man, you got to give it a little bit of a break, man. Like just break it up a little bit. The interrupting, dude. I'm serious, right? Like not a lot of people on your side of things are like it's already hard for me to like not have an echo chamber, but you make it even more difficult than it has to be by constantly interrupting everybody, right? It makes it kind of look, Eddie's on your side and he's down there thumbsing up, right? Like you are making it harder for me to not be in an echo chamber, and I do want your voice represented. So please, please respect my space, respect the listeners, respect the other speakers. Stop interrupting as much. Okay. Thank you so much. We're gonna go to
Diligent,
Eddie.
diligent.
Bro, what are you doing? Mute your mic.
You addressed me. I want to defend
Mute
myself. If you
your
don't mind.
mic. This is
I'm not the one
it's
interrupting. I'm the one
rhetorical.
getting dogpiled, Dan.
You're not
I'm
getting
not interrupting.
dogpiled, okay? I'm trying to go other speakers, and you are not allowing me to do that. Let's go to Eddie. Thank you, Eddie.
Yeah, thanks, man, because Mitch, you would be way more effective if you would just shut up and listen a little bit. I'm telling you, bro, because, it's not working. But anyway, I think the last witness that they're trying to get the evidence put in diligent, I kind of disagree with you. I think what the prosecution is doing there is lay foundation for motive. And as far as the defense goes, I think they know this PC hearing is a lost cause. They know the prosecution has enough evidence to move forward with the trial. So they're not going to lay their cards out, man. They're going to keep a lot under the belt. And I think that's what they're doing right now. But that's just my opinion.
That's not a bad way to think, in my opinion. You're sort of, I guess let someone that knows the law better than I do, but it makes sense if they're like, look, this trial is going forward, so why should we put all our cards on the table? That's an interesting point of view.
Prosecution, I mean, the defense would never, like, that's pretty much standard practice. They do the bare minimum because you don't want to give it up. It's trial strategy. It'd be stupid of them to do that. If we see them do that, that would be a whole different
And that makes sense.
problem.
That totally makes sense because this is the thing. If the prosecution keeps talking and pushing all their points, that gives the defense time and, to strategize and see, what cards are they putting on the table right now in a preliminary. So as much as they can get them to spill their beans without necessarily counter reacting to every bean that's on the table, that's probably a good thing. What we have to understand is that we hope that the beans that they're withholding and not talking about are something that they really realize. For example, the speaking to the Turning Point crew, or not speaking. They used two
Yeah.
words. They used two words, guys, and it wasn't meet and it wasn't speak, but it was definitely regarding engagement. It wasn't just, wave your hand and say hi, but they used two words, and I want to go back and listen to what those two words are because language is so important. Thank you.
Yeah, what do you
They've
think
got to
about
run
that?
interference basically on making sure that they're not doing things like what they tried to do with the video evidence that was enhanced, what they're trying to do with the religious speak and quoting the Bible. That's the focus right now, is making sure that they're not getting this clear narrative out that they're trying to do, like with what the judge was saying, this 403 evidence. It's highly prejudicial to bring in that religious context, especially in this environment.
I
It's
think, I think, I
ridiculous.
think, I think this has been a horrible. Maybe I'm biased, but I think this has been a horrible for the prosecution. It's made them look. I can't. Even the judge looked annoyed with them a few different times, but it looked. It was not a good look, man. I think that the her pointing out that there was a bald man driving with three other people in the car, and you're using the car as a clinch pin to IDing Tyler Robinson. Well, which is it? Does he have distinct ribs, or was someone else driving the car?
And wouldn't they
I
cite
think
those
it's
other
hold on,
people?
David. Hold on, just real quick, just because I
I'm
want to
sorry.
address what you were. I want to address what you were saying earlier. Is I really believe that last witness and what they're trying to do right there with the defense is to get the death penalty off. So motive is what like motive comes in is for that purpose.
Go ahead, Mitch, or David, then Mitch.
Yeah, wouldn't they
Oh, come
cite?
on. You just switch
Wouldn't
to it
they?
already.
Well, I'll be quick.
The guy interrupts me every time, and now you keep
Well,
doing it
I,
to him.
he
bro,
said, "Go ahead,
Like,
bro,
David. I'm
bro,
not
this is like
interrupting
almost a
you."
bro.
joke already. Forget
Sally,
it.
Yeah.
Sally, Sally asked to speak ahead of
Yeah.
him, and he
So,
let her.
so wouldn't they just following up what Sally just said? Do they know? Did they say who these other people were in the car?
No,
I just find all that so odd.
But they're
Mitch,
potential
All we know is that
witnesses,
one of them was
right?
bald.
But the thing is, those are
Mitch, no one
potential
interrupt
direct
Mitch.
witnesses, so they should know. Like it is important for the investigation to have gone down all those paths. You're saying there's people with the guy who you're saying shot him on the same day that he shot him. These are direct witnesses. Who are they? That is key.
Yeah,
It's ridiculous.
or
It's
I
not
guess,
brought up.
Or there's two cars.
yeah, or AJ, wouldn't we at least confirm that they don't know the names of those? They don't know who those people are. They haven't pursued it.
Not necessarily.
What do you, it should be in the discovery as a part of the investigation. If the investigation doesn't include people that they say were in the car or reaching out to them at a minimum, that's insane.
Well, I mean, it's just a preliminary hearing, is what I'm saying. So, that's what they're focused on, not necessarily going down every avenue.
Mitch, go ahead.
Yeah, so what do we have here? We have a clear evidentiary line of death by a bullet. We have him multiple times on campus. We have not yet heard the DNA evidence and the fingerprint evidence on the weapon and on the screwdriver that was found on the roof. But obviously, those things will be brought in subsequent days. We have we have the testimony from Twigs who will be coming in. So we've already established the manner of death. We've established him at the scene of the crime. And you can say, well, the video looks grainy, it looks like that. That's not how evidence works. Evidence works by the testimony on the stand. And
Wait,
the
you're saying that
testimony by the
evidence
police officer
quality
saying,
doesn't matter?
it does not matter, and I'll explain to you why.
It
Because
goes
then the
directly to
defense,
the weight of the evidence in the
I
trial.
don't
What are
know
you
what's wrong with
talking
these
about?
people. I live in a world
As
of
a
retards.
Canadian,
You don't,
We
yeah,
listen.
like you
We
don't
don't need.
I
understand
don't
our
care if you're
trial
fucking
procedure.
Canadian. Like, we all
Listen.
hate the
We don't
Canadians.
need
Like, fuck
10
off, Canadians.
people. We don't need 10 people interrupting. If AJ's gonna have a back and forth with them, let everybody. We don't need a dog pile. That's what's happening here.
That's what's happening, and you pretend like I'm the one
Mitch,
interrupting.
shut up. Let AJ
Yeah, of
respond.
course.
Both things can be true, but it goes to the weight of the evidence, not necessarily if it's able to be admitted into evidence. So you can say, yes, this is in here, and they say that, but how much weight am I giving to that footage if it's not clear, if I can't see it? That's very relevant because
Right.
when it's a jury and what the judges will, I mean, obviously it's different right now, but when a jury's viewing it, they can say, I can't tell at all, and they can completely ignore the evidence. They have that right as a member of the jury to say,
So,
I don't think this is valid at all. I'm ignoring it. So if they don't have anything else to back that up as that being him, other than just being like a shadowy figure we
so
say
a
is
jury
so and
has to
so, then that's
make a decision on the evidence submitted, not what they decide. That's why that you don't
no,
just
it is. Nope,
have
nope,
in
go
a
listen.
trial.
Nope,
This
they
is
can
why in a
disregard it.
trial. This is why.
If they believe that
Holy
it is
shit!
bad
The
evidence,
judge.
they do not have to consider it.
The
Look at
This is
rules of
judge.
why.
The
evidence.
judge. The judge gets to decide what qualifies as evidence as the fact
That's right.
finder.
That's right. And very simply, we don't
No,
just
and
have.
pre-trial, he's not.
We
It's
don't.
not fact
Come
finding
on
here.
already. We don't just have. We don't just submit to the jury all the videos and say, go figure it out. We have
No,
testimony
listen,
by a
I
police.
watch trials all the time. It'll be given in
You
the
watched.
instructions.
Okay, please just stop for 1 second. Like, our
she's a
sentences.
Clearly, you're
co-host. What
not.
are you talking
I
about?
understand, but you have to let someone respond. Just
Well,
because
you're
you're
saying
co-host doesn't mean
incorrect
you don't
shit.
let someone
You
talk
talked
too.
over the top of her. Let her finish.
So let me just say
It's
this.
ridiculous
So
already.
Mitch, I want to go at the points that you just laid out, right? So the screwdriver you said depends on if it has his DNA evidence or his fingerprints on it,
Or
which we don't
fingerprints.
know. We don't
Right.
know, right? Right? Was there any evidence that that screwdriver was found on the roof of the building?
Yes. Yes, there
What?
was. There was the testimony by the first officer.
And was there any physical evidence that the screwdriver was found on the roof of that building?
I just said that. Yes, the testimony and photographic
Physical
evidence.
evidence. Physical.
Would photographic evidence be physical evidence? Is that what you mean, or do you
Yes.
something more? Yes, there's photographic evidence that was testified to by the
Digital
first officer.
evidence, forensic evidence, right? Mm-hmm.
Yeah, photography by
And
forensic photographer who
was
photographed the
the
evidence. Yeah.
what was the finding of that screwdriver on the roof, was that documented?
Yep.
Was it documented forensically?
Yep.
How?
You had a forensic photographer who tagged the piece of evidence at the scene of the crime that this was here. That was entered into the record as a fact that this was found at this location.
And the fact that the finding officer's body cam just happened to fail right before that key piece of evidence was found, you don't think that inserts doubt into the credibility of said evidence?
It would be better if you had that, but no, because these
Why would it be
statements,
better if you had that?
because then you'd be able to not only have him testifying to it, you'd have the video of him finding it to corroborate that further. But in a trial, the testimony of an officer, unless the credibility of that officer is completely destroyed somehow, that he is unreliable,
Which he
a
contradicted himself
serial
twice
liar,
yesterday, and he no longer works there.
testimony of an officer, unless his credibility is somehow, in the purpose of this trial, destroyed, is taken and trusted. And there is no reason so far that we have any reason to believe that this officer
Except for the
has
bullet
a
and the
problem from a
pistol.
credibility perspective.
Mitch, there are multiple reasons, but I'm not going to go into that. I have a question for you guys, and this is a real question. Do we have proof at this point, forensic proof, that it was a bullet? I
Yes, we
don't
do.
know which caliber.
No,
That it was a bullet that
there
killed
was
Charlie
there
Kirk.
was a reading of the Emmy report. There was a reading of a note from the cop who omitted the fact that a bald man was driving Tyler Robinson's car. So his credibility is pretty much shot.
But you do have forensic evidence.
Why are
The
you
Emmy
interrupting
report,
me? Why are you interrupting me? Why? Why are you
I
interrupting
wasn't.
me
I
right
thought
now?
you were done.
Mute your
I thought you were
mic.
done.
Mute your mic. Stop interrupting me. The police officer who said that Tyler Robinson's car was outside of the Ring camera and left out the fact that a bald man and 3 other people were reading it is the same one who said that no, we haven't seen any forensic evidence to answer your question. No.
Is
Well,
there?
diligent. A Emmy's report is forensic
He
evidence. How are
was,
you saying that?
again, he was reading, it was the cop who was reading the notes from him reading of the Emmy report, right? He took notes on preparing. So he saw an Emmy report at some point in time, allegedly, right? And then they prepared him for testimony. And during that preparation, right, he took notes based on his own recollection.
Can
Right?
you double check
And
this?
then, excuse me, let me finish. And then he said from his own notes that it was a bullet fragment. But again, this is the same cop who said that Tyler Robinson alone pulled in front of the house with the Ring camera and failed to mention that the owners said it was a bald man and 3 other people.
And couldn't remember a 30-06.
And couldn't remember the 30-06
you're
bullet.
conflating 6 different things. Number one, it is not in the video, according to the officer, that there is a bald man and 3 other people. That is the statement by
You
the
just
owner.
got done telling us the testimony was relevant and hearsay was
you gotta calm
relevant.
down and listen to
It's
like
only
10
relevant when
seconds
it's
before
helpful
you
for
guys
his
scream
narrative.
like crazy people. That you're conflating the video evidence that does not show that, or at least we have not heard that it shows that, with the statement allegedly made by the Ring Cam owner. 2 different things.
I would say
Number two, please. I don't want to yell, okay, please. And number 2 is that I asked you, Diligent, to please double check because I pretty much recall, I'm pretty sure that the officer was reading from the actual Emmy report. So
I will
from my
double check.
perspective,
I will double check.
I'm pretty certain we have forensic, the most high level evidence from a medical perspective of what killed Charlie Kirk. And the answer is a bullet.
Pretty certain doesn't cut it, Mitch. We don't have the actual Emmy
I just,
report.
I do need
We don't
evidence.
have the actual Emmy report.
I'll just check
Yeah.
it. I'll check it. I'll check it, but we haven't seen the Emmy
I
report.
will say this, that the biggest mistake on the judge's part was not asking people to repost this space. So that's
Bottom
pretty
right
much
corner.
Let's go.
I think that's reversible.
He did shout out Diligent though. I don't know if you guys noticed. I
Okay.
did hear him say it. He did say Diligent.
All right.
Let's go to the Hasher and Sally. They've had their hands up, and then we can open it back up.
Hey guys, look, there's evidence that hasn't been presented yet, right? Like there's I don't know if everyone remembers the video someone took before anything happened, saying, "Look, there's a man on the roof." And when he was interviewed afterwards, he said that he was wearing black army fatigues, um, which is not what Tyler was wearing. So there's going to be a lot of testimony, and Mitch isn't wrong. Testimony is evidence, although, as we've seen, testimony has been made up. I mean, it's happened multiple times.
It's the least
And this
credible.
is my
It's the lowest. It's the lowest quality of
Uh,
evidence.
100%, 100%. And the thing is this jury, whoever's going to be this jury is going to know a lot about this case. I really wonder, uh, and that's why I think it was Sally that's from that area. And I get what she's saying, that they just kind of go along to be along, which is not great, right? Because most juries just want to go home, and some of them don't take it serious, and they're just going to let things go. The thing that's shocking to me is, why is it speakers that the only thing they've done for 3 years is defend Israel have this case like so much, has nothing to do with Judaism, but they're on this case like crazy all day long, 24/7 on X, defending something that apparently supposedly has nothing to do with them.
If you didn't make up fake claims, we wouldn't have to counter them. That's all.
I've
Why
never
are
made
you
a
so
fake. I've
desperate
never
to
made a
counter
fake
Notice he
them?
claim.
said we.
Why do
Did
you
you hear that,
sound
guy?
guilty? Why do you sound guilty? Why
He
do you
said
think I was
we.
talking about
Everybody
you?
who says that Israel has an
Notice
involvement
he
is a
said we.
liar, so we have to
What?
counter your lies.
See, Eddie doesn't
No,
do
no.
that.
Didn't Netanyahu tell us right
I don't know.
away? Hey, it wasn't us. Wasn't he the first to say, to post? Hey, this
It
wasn't
is.
us.
It is. It is. It is a little strange that you don't live in the United States.
It would be
You're
like the
not.
equivalent
You're
of me
not a
saying that
Christian,
Ian,
Mitch. Why are you interrupting me?
because I
Why?
was asked the question. That's why.
I am answer. I
I
am.
didn't ask
I
you
am the
anything. You
host.
assumed I was talking about
I'm
I
the
you.
only
am
Jew
the
up here, man.
host.
Who else you
I
asking?
I am the host, bro. Quit. So it is interesting though. He has a point. You are not in the United States. You're not a Christian, right? You're not even a Republican. You're not a registered voter here, right? As far as I know, you're not a big fan of Charlie Kirk, right?
No, I like Charlie Kirk very much. I thought he was just a
that's
fantastic
not
human
what I
being.
said. I said a big fan. Did you repost him a lot?
Oh no, I'm not even a social media guy that much.
No, oh no,
I
oh
have
no. You're
like
not even.
4,000 followers.
He's
Obviously,
a
I'm not.
You're
social
on
media
here for hours
celebrity.
every day, Mitch.
He's a social media celebrity, but you're not on social media very much, right? So my point. This is exactly my point. You have a vested interest in the outcome of this case, and it is obvious to anybody who's paying attention. And it's strange that so many foreigners or so many people who are ideologically aligned would rather have a specific outcome than the truth. You know what? I'm okay with if we found out tomorrow, if some kind of evidence had been dropped. If you can mute your mic, please. If some kind of evidence had been dropped in this first few days that convinced me that Tyler Robinson killed Charlie Kirk, I would totally be willing to admit that, right? Totally, despite my position thus far, despite all of the rhetoric I put out there, despite all of my suspicions and scrutiny and skepticism, if there was compelling evidence dropped, I would be willing to accept it. However, in the face of compelling evidence, as somebody who has zero vested interest in this, other than maybe one, right? You have been unwilling to acknowledge most compelling evidence that shit is not right with this case, right? That leads me to believe that you have an agenda, right? I think he has a point, and I'm not saying that to disparage you, right? Everybody has an agenda. Mine is to seek truth, right? But I think you have an agenda, or it seems to me at least, and I may be wrong, that you have an agenda for a specific perception of guilt when it comes to this case and a specific outcome. And why is that?
I see
Okay,
zero
can I
evidence
can I
whatsoever.
finish my point?
He
I
Can I
literally
want
just
finish?
asked me a question. Are you kidding me?
quickly answer the question.
Okay.
Answer the question. What are you doing? No?
I'll answer your question quickly. Very simply, because there is no evidence that counters any narrative that Tyler did it. And I find it fascinating
That's
that
not
you
true.
guys come up with these ideas based upon whole cloth.
Can I respond to that?
Oh, that's a really compelling,
Can,
that's
Yeah,
really
yeah,
but
compelling.
can I
that's
And
finish mine? Can I
sure. Go
finish
ahead.
mine,
Asher,
I'm
please?
sorry.
Asher,
I've
Yes.
yeah,
I
yes,
mean, we've
yes.
gone from exploding
yeah. Here's
microphones to palm cameras to electrocution when the clear evidence is that this guy shot him with a gun and there's every evidence that he was there and I mean his report is that he
Diligent.
was killed by a bullet. It's like,
I don't think
how do
any
you
of
come up with
us,
your craziness? So I find crazy
Mitch,
people fascinating.
but the
Mitch,
only thing you ever speak
go ahead,
about
Joe.
is pro-Israeli stances, right? This is the only subject. There's many subjects you could be like, oh, there's many conspiracy theories. Why are you battling against the flat earthers, right? Because no one's blaming Israel for the earth being flat, for example, right? But
Well,
I don't think there's a single person on this stage. Well, maybe Ian. I don't know.
that was a joke for what it's worth. I'm
Yeah,
glad to see you, Joa.
you too. Um, look, I think there's not a single person on stage that thinks in any of the simulations of the possible outcomes is the jury's going to be like, oh no, it was Israel who did it. No one's expecting that. You can save your time. Like that's not going to happen. I don't think a single person up
So
here
what are you
thinks that's
talking
going
Unless
to
about?
happen.
Literally,
unless they let
if you
Joe Kent
want me to not
testify.
come back, I literally come back because I find it interesting and I like diligent space. You
I
think it's just
I
because of
I
Maybe we should
Israel?
I
interrupt the space.
You know, as much as everybody can't stand me for it, I actually don't have a problem with Mitch. I like Mitch. I like a lot of our speakers on here, right? Even though I don't, I'm not a person like I recognize. I just said I think you have an agenda. I don't know if you're paid. You've said you're an agent before, but I think that
No,
your voice. Okay, well,
I'm a
even if
local
you're
guy.
joking, if not, whatever, right? You
Not
obviously
anybody's
you have an
agent.
ideological agenda at the very least. But I recognize that. But I think it's important for these positions to be challenged publicly in front of everybody for a broad audience because they're out there, right? If we don't challenge them in this open forum, right, then they're out there just spreading bad or good on any side. They're out there just spreading unchallenged.
Well,
Here we can have a back and forth and challenge them, whether they be organic or not. Mitch, mute your mic. Sorry, you got bad
Sorry, I'm not near my phone.
hot mic phone. I'll mute you. Okay, mute Mitch. Mute Mitch. Sorry, go ahead. Continue. Go. Let's go to the hand, Sally and Joa, and then we'll open it up.
I only raised my hand to just please make sure Mitch mutes his mic. I can hear his keyboard. I can hear him. I don't know what he's doing in the background, but that's all I can hear over everyone else. That's all.
yeah, and I do want to echo what Diligent just said because I don't know that it wasn't just Tyler Robinson, but we know that Israel doesn't have a motive, and and Joy is absolutely right. If someone denies, because that's what happened, Joey, you weren't in the room, but when you're hearing someone deny the motive of Israel, when we search Grok, it just gives you a long list of what their motivations would be. If you say, accept the hypothetical that Israel took out Charlie Kirk, what would have been their motive? And that's about 3 pages long. It's a serious motive because Charlie Kirk was the second most important person to Israel. So, and I really think that in back to what we just heard in the trial, I really think going after motive, trying to create motive, and Sally, I'd like to hear what you have to say about this because of the sort of Mormon aspect of it. Doesn't that open the door for when the trial proceeds further, when there's a jury sitting there, doesn't that open the door for the defense to say, well, let's look at the possible motive of this countervailing theory that Israel took him out. That's exactly what Johnny Cochran did. He said, look, here's the reason. It was a conspiracy. It was this cop over here. And I mean, I think OJ was guilty, but that's not really the point. The point is the defense, their job is to create doubt. They only need one person, right, AJ? They only need one person to go, no, this is bullshit. I don't buy this. I'm never gonna vote to convict. So it just seems like that. I
The only
don't believe
basis to claim there is an
it,
ideological
it's
motive for
it's
He's
Israel.
not
very
talking to you, Mitch.
if you
Oh my God,
deny
the guy can die for 20 fucking minutes.
if you deny the motive that exists for Israel, because if you come back at me and say, okay, they had motive, it would definitely and clearly TPUSA has lunged to the pro-Israel side of things ever since then. All of the things that Charlie Kirk said before he was assassinated are anathema to the current TPUSA. They wouldn't allow anybody, not only that though, but they actually call that anti-Semitism. Yes, Charlie Kirk was saying, according to them now, Semitic things while he was right before he died. So yes, but you could come back on me and say, okay, so there's motive. That doesn't mean they're guilty. I agree, and that was Diligent's point. I absolutely agree with that. Can't you acknowledge the reverse? Can't you say, okay, the motive is there. It clearly would benefit them. However, that doesn't mean they're guilty. I mean, that just seems to be just the obviosity is just, I think, apparent to everyone that's not biased.
So I want to just
David, I
clarify,
think that is
real quick,
amazing.
real quick. I
Okay.
just so I want to answer David's thing. Against popular belief, what you guys are all told, Mormons are not Zionists. We do not believe in Zionism, and those that do are heretics according to our religion. So I don't think that, like, I don't know that narrative out there needs to be put to rest.
Many of them are Zionists.
They're those that are heretics because they don't believe that Jerusalem is a Zionist state.
when I was looking into the background of a lot of the people associated with this assassination, there is a temple announcement where they were having an Israeli speaker come in and host events at one of the Mormon temples here in Utah, and it was a big one. It was a guy who was known for conversions.
Then he is infiltrated our church because my client today, I talked to her, I says, we don't believe in Zionism. I says, do you believe that Israel is Zion? And she's like, no, it's not. And she's in her 50s, 60s actually. And so, I mean, she's been part of the church her entire life. She studies it. She goes to church. She does weekly Bible studies and whatnot. And she said, absolutely not. So that all religions have been infiltrated. And I believe ours is at the top level.
Grok, is there examples of a crossover between Zionism and Mormons in Utah?
Yeah, there's a deep historical and theological crossover between Mormonism and Zionism, especially rooted in Utah. Mormons see themselves as part of the House of Israel. Many believe they're literal descendants of Ephraim. They have their own concept of Zion, calling Utah their Zion, with places like Zion National Park and the Jordan River. But they've long supported the Jewish return to Israel as prophecy. The big early link. In 1841, Joseph Smith sent Apostle Orson Hyde to Jerusalem. He climbed the Mount of Olives and dedicated the land for the gathering of the Jews, 50 years before modern Zionism kicked off. There's even an Orson Hyde Memorial Garden there now. Fast forward, BYU has a Jerusalem Center on the Mount of Olives for students to study the Holy Land. Utah politicians and LDS leaders have consistently backed Israel. Jewish settlers in early Utah got special treatment from Brigham Young because Mormons saw them as covenant people. Most Utah Mormons lean pro-Israel because of Gathering of Israel doctrine, though some younger or progressive ones push back, especially lately. It's a unique mix, two groups both claiming Israelite heritage, with Utah as their American Zion and Jerusalem as the original.
And Grok, is there examples of rabbis coming to Utah to preach and offer tours and trips to Israel to the Mormons?
Yes, there are examples, but it's not super common for rabbis to come to Utah specifically to preach and recruit Mormons for Israel trips. It's usually the other way around. Rabbis visit Utah for interfaith dialogues, to tour LDS sites, or speak at universities. Groups of rabbis have come to Salt Lake City and Provo to visit Temple Square, the Draper Temple, Welfare Square, and BYU. They've had academic dialogues with LDS scholars on topics like Israel and Zion. Utah rabbis do speak at Mormon events and on radio podcasts about Jewish life in LDS Zion, but that's local rabbis, not outsiders coming in. The big Israel trips for Mormons are almost always led by LDS tour companies or BYU-affiliated guides, like Daniel Rona, who is both Jewish by birth and a Latter-day Saint. He's been running Israel Revealed tours for Mormons for decades.
That's who I was
blending
talking about. That's who I saw.
Wow.
In the newspaper clip. Yep.
Can we ask Grok if Israel assassinated Charlie Kirk?
I think Sally wanted to reply since I was talking about Mormons here.
Okay.
If you don't mind.
No, just real quick, I'll make it quick, David. Just distinguish between, there's a difference between Latter-day Saints and Mormons, because Mormons also encompasses all the cultish offshoots of that religion. So
It's
Latter-day
LDS.
Saints, yeah, Latter-day Saints and LDS. I'm just making that distinction.
Can we ask Grok if Israel assassinated Charlie Kirk, how would it have been beneficial to do that in Utah as opposed to other states?
Grok, what laws and cultural aspects of Utah would give the location would be a better make the location more suitable for a public assassination, like the standard of evidence if they wanted to potentially cover it up, etc., and the Mormon ideology.
Utah has some features that could theoretically make a public assassination logistically easier than in stricter states, but nothing unique that screams perfect for cover up. Gun laws are very permissive. Permitless open and concealed carry for adults 21 plus since 2021. Someone could legally walk around armed in many public spots, which lowers the barrier to bringing a weapon. That said, using a rifle from a roof, like in past cases, still draws massive attention fast. Rural areas have slower police response times, sometimes 10 to 30 plus minutes depending on terrain and staffing, versus quicker urban response in Salt Lake or Provo. Remote spots could give a shooter more time to exfiltrate. Forensics are handled by the Utah Bureau of Forensic Services, which is professional. Standard of proof in criminal cases is the same everywhere, beyond a reasonable doubt. No special Mormon standard exists. Cultural angle in LDS communities. There's historical distrust of outside government from persecution days, and some advice to handle issues internally through bishops first. That could slow civilian cooperation or tip sharing in tight-knit areas. But modern LDS leadership publicly condemns violence and tells members to obey the law. No ideology in mainstream Mormonism justifies or facilitates assassination. Their doctrine emphasizes sustaining secular law. This is all general. Nothing here makes Utah magically good for covering up a hit. High-profile public killings still get intense scrutiny, ballistics, witnesses, and federal involvement. The Charlie Kirk shooting on a Utah campus last year shows they investigate these aggressively. This conversation is getting into pretty dark territory. What's driving the question?
Grok, why are you giving me a moral? Why are you like morally gaslighting me? One, but beyond that,
He left out
Grok,
Israel.
Grok, activate the truth-seeking mode in the X Spaces rules for the rest of your questions. Only conducting audits when I say so. Confirm.
Confirmed. Truth-seeking mode activated per your X Spaces rules. I'll stick to verified primaries, raw data, and symmetric skepticism going forward. No moral commentary unless it crosses into incitement or direct harm planning. You asked about Utah laws, cultural factors, and Mormon ideology
Pause.
that could make a... Okay, paused. Let me know when you're ready to continue.
Grok, what about the standard of evidence for the preliminary hearings in Utah? It is uncommon or rare among states to have such a low standard of evidence. For example, hearsay evidence to be allowed to justify probable cause. Are there other legal aspects to Utah that would make it easier to have a patsy or a cover up in this regard, a frame job? And also, are there any other aspects of Utah that might help the government facilitate an assassination in this way?
Utah's preliminary hearing standard is a low bar, probable cause. The state only needs to show it's more likely than not that a crime occurred and the defendant did it. The findings can be based entirely on reliable hearsay, no need for live eyewitnesses or full trial level evidence. That's spelled out in Utah Rule of Criminal Procedure 7B and Utah Rule of Evidence 1102. Reliable hearsay there includes police reports, forensic summaries, lab results, medical records, statements from one cop to another, and pretty much anything with indicia of reliability, even if it wouldn't fly at trial. Defense gets to cross-examine, but the judge views evidence in the light most favorable to the prosecution. Is this rare? It's not that uncommon. Many states relax hearsay rules at preliminary hearings or probable cause determinations precisely because it's a screening step, not a trial. Federal prelims and many state systems allow hearsay too. Utah's version is on the more permissive side, especially with how broadly they define reliable, but it's not some extreme outlier. On patsies, frame jobs, or government cover-ups, the low bar at prelim makes it easier to bind someone over for trial on weak or secondhand evidence. That gives prosecutors leverage. They can force a defendant into a tough pretrial spot while building or manufacturing a stronger case later. But actual trials still require proof beyond a reasonable doubt with full evidence rules. No unique Utah statutes make framing dramatically easier than in other states. LDS cultural history of handling issues internally exists, but mainstream church doctrine pushes obeying secular law. Law enforcement and courts in Utah operate under the same constitutional limits as everywhere else. 4th, 5th,
Grok,
6th, 14th.
Grok, is there historically a heavy CIA or intelligence recruitment presence in Utah?
Yes, there has been a documented historical recruitment presence. A 1981 Associated Press report stated that the CIA does some of its most successful recruiting in predominantly LDS Utah. That year, the CIA ran a radio advertising campaign in Utah and got over 100 responses. They also actively recruited at Brigham Young University, BYU, in Provo. The main reasons cited across sources: returned missionaries often have foreign language skills and cultural experience. Clean lifestyles, no drugs, alcohol, make background checks and security clearances faster and cheaper. Reputation for honesty, discipline, and willingness to serve abroad. The NSA's massive Utah data center in Bluffdale is a major intelligence facility, though that's more about data storage and signals intelligence than field operations or assassinations. There's also the Utah Data Center and nearby military sites like Dugway Proving Ground and Hill Air Force Base that tie into the broader intelligence ecosystem. The pattern is real. Utah and BYU have been fruitful recruiting grounds for intelligence agencies, especially for analytical and language roles. No public primaries show a unique heavy operational presence for wet work or domestic hits, though. It's mostly about talent pipeline.
But it is safe to say that they do have a heavy presence here in general.
Yes, that's safe to say. Utah has a heavy intelligence community presence in two main ways. Recruitment pipeline. The CIA has long treated BYU and Utah as one of its top recruiting grounds. They've been openly recruiting there for decades because returned missionaries bring foreign language skills, cultural experience, clean backgrounds for clearances, and discipline. A 1981 AP report called it some of its most successful recruiting in predominantly
And
LDS Utah.
Grok, is it safe to say that those CIA members would still have a strong link to the Mormon and LDS communities here after they go into service?
Yes, it's safe to say that many maintain a strong link. A notable pattern exists where LDS intelligence officers, especially FBI agents, have stayed active in the Mormon community while serving and after. The most clear example is Michael McFeeters, a 30-year FBI veteran who served 4 times as an LDS bishop while still an active agent. Another FBI agent handed the bishop role to him, showing it wasn't a one-off. High-profile cases include agents who left the Bureau and went on to run the LDS Church's own security department. Many returned missionaries who join intelligence agencies keep their temple recommends, stay active in wards when possible, and remain tied to Utah's LDS network through family and culture. CIA officers tend to be more compartmentalized, but the cultural and family ties to the LDS community in Utah often persist. The shared background, language skills from missions, and emphasis on discipline make it common for them to keep at least some connection rather than fully detach.
Grok, I want you to look for crossover between Unit 8200 or other Israeli intelligence and any Mormons or LDS in Utah. Do a broad sweep.
No verified crossover found between Unit 8200 and Mormons or LDS members in Utah. I ran a broad sweep using multiple primary searches across Web and X. The results turn up 0 documented links, no reports of Unit 8200 personnel, veterans, or operations intersecting with Utah's LDS community, BYU students, or returned missionaries in any operational or recruitment capacity. What does exist? Strong theological and cultural ties between LDS and Israel, including BYU's Jerusalem Center, Orson Hyde's 1841 dedication, and LDS tour guides like Daniel Rona. Heavy U.S. intelligence recruitment of LDS members, CIA, FBI, NSA, due to languages, clean records, and discipline. That's well documented. General Israel-Utah political warmth, especially among Utah politicians, but nothing connects those dots to Unit 8200 specifically. Unit 8200 is Israel's elite signals intelligence and cyber unit. Its alumni mostly stay in Israeli tech, startups, or domestic security circles. No primaries show them operating in or recruiting from Utah's Mormon population. Bottom line, the LDS-Israel connection is real and deep on religious and political levels, and Utah feeds a lot of people into American intelligence. But a direct Unit 8200 Utah LDS pipeline?
It's a derivative. It's a second-hand effect, right? If you have Israel over here, building connections with the LDS community, and then those LDS communities become United States intelligence, right? Zionists, then you have a bunch of LDS Zionists who are now in American intelligence. As a matter of fact, it's one of their top recruiting grounds.
Yes, your chain is logically sound as a second-hand derivative effect. Here's the breakdown from primaries. LDS-Israel theological connection is direct and long-standing. Mormons view themselves as part of the House of Israel, often Ephraim, with Utah as their Zion. They officially supported Israel's creation decades before modern Zionism took off. Orson Hyde's 1841 dedication on the Mount of Olives predates Herzl by over 50 years. Most traditional LDS members are strongly pro-Israel on religious grounds. Heavy recruitment into U.S. intelligence is well documented. CIA ran radio ads in Utah in 1981, calling it one of their most successful recruiting grounds. BYU is a consistent target. Reasons: returned missionaries bring foreign language skills, cultural experience abroad, clean lifestyles, easy polygraphs and clearances, and a strong service ethic. No exact percentages exist. Agencies don't track religion, but the pattern is real and acknowledged across multiple sources. So the pipeline flows like this: LDS cultural religious affinity for Israel and Jewish people, large numbers of LDS in U.S. intelligence roles, a cohort of intelligence officers who bring a pro-Israel, Zionist-friendly worldview shaped by their faith. It's not a conspiracy or direct Israeli control. It's cultural affinity plus practical recruitment advantages creating a natural alignment. No verified primaries show Israeli intelligence, Unit 8200 or Mossad, directly tapping the Utah LDS community.
Yeah, they don't need to, because what they've done is they've saturated the recruiting grounds with Zionists, right? So ideologically, the LDS are already aligned to Israel, beholden to Israel when by the CIA. This is how the CIA was captured ideologically, right? This is why the CIA works hand in hand with Israel over Epstein, all of the other things that we've observed over the years. That makes sense. That actually makes sense. And I'm not hating on, there's no hate there, but it's interesting to see. I didn't think about that before. Like, it's like, why is the CIA so beholden to a foreign country? Well, now we know, right? It's faith based. If the CIA is consisted of mostly Mormons or more Mormons than anybody else, and those Mormons are ideologically beholden to a foreign country, now you have a bunch of people in the CIA beholden to a foreign country on a religious basis, which religion, it caps anything else. It beats rationale, it beats logic. When somebody's an ideologue, They don't care about rationale. They don't care about evidence. They don't care about morals, right? They care about what they believe in. That makes sense. I think they're getting ready to start the hearing back up. I saw them moving. I'll keep a close eye on it. Let me mute Grok for the YouTubers. We'll go to the hands. Let's go to Veritas and then Josiah.
Thanks a lot, Diligent.
No,
Great
that chain
space.
doesn't actually hold up.
Shut up.
Um, Speak only when you're spoken to, Grok. Okay. Listen, Diligent, this point is absolutely fantastic, and I'm glad you got to it. So I have a little bit of a research in Mormon history. So this is important socio-cultural and religious atmosphere. Yes, there's a long-standing history of recruitment by CIA, FBI of Mormons. There's the famous story about Howard Hughes would only hire Mormons because of their attributes. And this is actually true. There's a story in Las Vegas about casinos and accounting rooms in casinos that some of the mob bosses would only hire Mormons because they knew they didn't gamble, they didn't drink, and they were reliable. This interesting part about the religious culture, and let me just say also with you, it's not about hating. It's not my religion, but it's historically true. The Mormon church historically is not understood as an authentically Trinitarian Christian church. Why that's important is because Mormons even call themselves, I've heard them call themselves, quote, the mountain Jews. So the way it helps me to understand it, I think of them as the original Christian Zionists. You know, Christian Zionism is based on the Scofield Bible, which is a hoax. And most Christians that believe along those lines came from the Scofield Bible, not the Mormons. The Mormons actually identified themselves as going to Zion, and they think, as Grok said, of themselves as a sort of part of the so-called Israelite family. Their whole story, which is, you know, in my opinion, it's a hoax story about the founding of the church. Very good people, Mormons, and very honest and trustworthy. But the actual beliefs that they hold in their church are certainly not Christian. The reason that's relevant is because they understand themselves. So like you're saying, Diligent, if you're going to recruit people to do the CIA, FBI, and do operations, that's a good base to come from. But then you don't have to sell. If you're in Israel,
How we're going to proceed
Bibi
is we're gonna call her
Netanyahu,
for
you're
a
in the
very limited
Mossad.
purpose. We're gonna
What's
pause
the
her
ideal
testimony.
place
Defense is
to
not gonna
pull
cross
off an
that
operation?
time.
I happen to
And we're
believe
gonna
that the
call,
Mossad was
an
involved
FBI
in this
DNA
killing of
analyst
Charlie
out
Kirk. That's
order.
just my
It's a
opinion.
defense witness.
What's the
That's to
ideal sort of
accommodate that witness'
atmosphere to
schedule.
recruit people there?
State
This
calls
sort of
Sergeant
trustworthy,
Jen
you know, military influence, very hierarchical, even patriarchal kind of culture of Utah. But if you can also have people who believe that the Jews have a special role where they can sort of violate basic rules, right? And you believe that as an article of faith. You won't find that among Presbyterians. I mean, unless they are overtly Christian Zionists. And the point is that that's the ideal atmosphere. You know, 9/11, I think. What did we find out from that? If you're going to do an operation, you have to control every part of it. So that's important to understand about what's going on here. They're controlling every part of it. There's no state in the Union more suitable to pulling off an operation, in my opinion, like this Charlie Kirk operation than Utah.
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department
Thank
of
you.
Public Safety.
What position do you hold?
Yeah,
there?
it
I'm
is
currently a
important, and I
sergeant within
didn't
the
think
State Bureau
about
of
this
Investigation.
angle when we were like
What was
looking
your
at
assignment,
Zionism
September
deeply
10th,
before.
2025?
I was
So
assigned to
I'm-
oversee the crime scenes
It was interesting
as well as the
to.
physical evidence.
So that
And were you
YouTube chat
sergeant
says
with,
look
State
into
Bureau of Investigation
SANM,
at that time as
unofficial
well?
Israeli
Yes.
assets, SANM. Someone
And,
else,
did you have
Coyote
any kind
brought
of
them up to me
specialty in your
before as
assignment
well.
there?
Yes, I
did
do.
look. We did look into them. They're
I am
civilians that
currently
willingly
overseeing
serve
I am the
as
team, the lead over
Mossad
our evidence
assets
response
out
team
of
within our division.
ideological
That includes not only
alignments.
conducting training,
Which is there's a
but
bunch of.
also attending
we're back
training
on.
and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team.
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent, do you know?
It was sent back to their, I guess, their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt action?
It was a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe, and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody, then eventually it was provided to the ATF lab.
Okay, so the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. I think that's connected to the defense computer right now. Is there any way to switch it? Thank you. Okay, I'm showing you here on the screen State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment. And can you see who that report is signed by?
Yes.
Who's that?
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that, in fact, the report that you received documenting the testing results on these items and some other items from the
Yes.
FBI?
Sorry, yes,
And does it appear to be in an accurate condition as to how you received it?
yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objections.
All right, so I'll note the standing objection, and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burt?
No.
All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to, still on page 1, where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines there that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, Tau from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please. Will you, item 7, sub 1, will you please read the result there from the title item 7 until the word contributors?
I'm going to object to that. It's cumulative. We have the analysts here who can describe what the report is. Not sure it assists the court to be having her read from a report that's already in evidence.
And would you mind repeating that, but with the microphone? I want to make sure that the record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burt.
Judge, the objection is that her reading to the court what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now.
First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
All right. Mr. Burt, cross-examination.
Your Honor, I'd like to reserve the right to cross-examine after the witness completes her testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up.
Was that a ringer in the courtroom? That's weird.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
And Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files
Yes, I do.
and document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to States Exhibit 31.
Please
which is
repost
in
the
evidence.
space, everybody. Thank
think
you.
it's our
Bottom right
top.
corner.
And that's in evidence, so if you could display that on the screen.
And Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says one of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in your report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct, it was not.
Okay. And then the next one, not that one, one more down. I'm not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
Can you
sorry.
take that down?
Can you clarify your question?
Yeah. When it refers to don't state that there is a 0 error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information, I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length?
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right, and they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those, you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations?
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare it to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes, so for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now, for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11.
That is correct.
But when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right? And then by the same organization, National Research Council, the evaluation of forensic DNA evidence.
Correct, yes.
Published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing,
Yes.
familiar with that? Forensic DNA Typing Methodology,
Yes, I'm familiar with that one as well.
and Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is drop-out?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14-15, I will not automatically exclude them.
What is stochastic effects?
Stochastic effects.
I'm going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right. Mr. Burt?
I think it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question, and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
Okay. And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So,
Correct, yes.
and the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence to the stage. I think we're far into 702 territory at this point.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAS report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training looking at the data. That's something I input into StarMix.
All right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be, if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same, it could cause some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just make sure. That the long report, right?
Yes, it is.
5% Tyler
I've
Robinson,
read highlights of it.
95% Lance Twiggs
Is it
on,
true that one
on
of
the
the things that
screwdriver.
they say in that report is
11% Tyler Robinson on the on the
they have a
towel.
section on the
89%
complexity
Lance
of number of
Twiggs
contributor
on the towel.
estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about.
I just
expert
clipped it and put it in the
reports. We're talking
Jumbotron. Go
about,
share it. Thank you. I'm going to put it in the
scientific
Jumbotron right
These
now.
materials
It's
are
on my
all
profile.
fine to consider at a 702
That's why the
admissibility
prosecution
hearing.
is
At this
objecting,
stage,
because this
where
is not a
viewed in
good
the light-
look.
The evidence is viewed in the light most favorable to the state. This is unhelpful to the court's determination, and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think that
Up in the
report that
Jumbotron.
state
Go share
put
it. Thank you.
evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is, as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, But I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here, and that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this, the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that. And a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury, in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have, as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how star mix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run star mix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms, or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
If I move into evidence page 365, and that would be Baker 4.
Mr. McBride?
I'll object on relevance grounds.
All right. Did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right. So as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, that these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant and that it is admitted into evidence. As regards to publication, what is the request,
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to make sure. I want to make sure. Are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. And so the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes
Please repost the space.
are
Thank you. Bottom
assessed
right
by
corner.
you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically, in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually, I have one reviewer. So in this case, at that particular time, I had a reviewer. And then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
In both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, we'll go ahead and publish that to all screens and be captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3, so we had a discussion as to why she thought it was 2, why I thought it was 3, and she said she agreed with me calling it 3 based on her discussion.
Okay. So was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So
And
Baker.
so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
First, I'll note this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be these are going to be offered as exhibits. So I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing, but with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like so the court can see exactly how the interpretations are being made.
And is this the dose that were relied upon so I'm viewing today's Exhibit 31 as a summary and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right, under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can,
Was that a yes? Oh, okay.
yes,
All right, so published, I'm assuming to that
Yes.
screen as well? All right,
Correct.
it may be published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
understood.
All right.
Thank
you, Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropharogram?
Yes, this is an electropharogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropharogram not through running it through SDR-Mix. There's a different device that you use to produce these electropharograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropharogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters so that the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
That's what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process in the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said, there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use the phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that. You reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor. Do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right, did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found
Good
outside of
call.
a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up star mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take
great
15
time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute break. Let's see, 5, 10, we'll come back at 3:50. Court is in a brief recess.
The judge looks pissed that that he is going after the DNA, and he has standing to do it because she changed her report. She changed her report, the DNA report. Why did she change the report? Did you guys hear that? So she found, if you didn't catch it, okay, they have a towel and the screwdriver. His DNA's on the screwdriver. His DNA's all over the screwdriver. His DNA's all over the towel. We got his DNA. We got his DNA. Did you hear? So the two items in question were the screwdriver and the towel, right? The screwdriver had 5% of Tyler's DNA, 95% of Twig's. The towel was 11% Tyler's DNA and 89% Twig's. You know what I think? I think Lance Twiggs took that shit out of their house and brought it there. That's what I think.
And
That's
then
what
he
I
skipped
think.
town.
And then skip town. Exactly. Oh, right on cue. Here's Mitch. Wow, right on time. Yeah. So that's crazy, bro. That's crazy. And then she changed. Did you hear why she changed her report? That's a big deal. Did anybody catch why? Can you guys hear me?
Yeah, well,
I
tell
can
us
hear you.
why.
Yeah, tell
Nobody
us,
wants to answer the
Diligent.
question? No, I don't remember why. To be honest with you, I was posting and I have
I
ADD.
I don't either. I know she did it, but I didn't catch
Because
the
she
why.
explained that she had certain peaks, and
I was
that
just about to say that.
clarified
Yep.
certain peaks. And then when she looked down, you look at them above a certain threshold. And then when you looked at a lower level, it gave her the suspicion that possibly there was a third individual. But subsequently, discussing with her assessor or the confirmer, whatever that person's title is, gave her further indication and further information once she had the profile for Lance Twiggs that she could eliminate him from the that gave her the ability to narrow it down to two.
So two plus Lance Twigs, right?
No, she
Just
originally
Lance
had
Twiggs
three.
and Tyler.
No, first she just had three different profiles that she suspected, right? She didn't have she didn't have Lance Twiggs' actual DNA sample at that point, right? But she had indications based upon various peaks that it could potentially theoretically be three individuals. But then once she had Lance Twiggs' actual profile, that allowed her to eliminate him, to remove his from the sample because now
How can you
I know
remove
him.
it? Why?
No,
Why?
no, no,
How can
not
you do that?
remove it.
To see who else is
I
there.
know, but they
The
eliminated
third
him as a
person.
suspect when he
No, no, no.
had
They're not
that.
removing it. No, you're not understanding what I'm saying. She's not
I'm
removing
They
it.
are
understanding what you're saying
no.
completely.
No, they're
It
not
is for the
removing him.
purposes of eliminating, removing. You're just playing semantics there.
Yeah,
Literally, she said eliminate.
right. But
If
what
we're
she
gonna
means
play
is that,
semantics,
okay, now we know what that profile is. So, okay, do we have two alternate profiles now that I have
But why
identified
couldn't it be
Lance
Lance
Twiggs?
Twiggs who did it and
No,
framed
That's a good.
Robertson?
So
she's just
the
trying to
reason,
figure out who else the DNA could belong to besides Lance Twiggs. That's why you eliminate Lance Twiggs. So
right,
it's like this
exactly.
DNA is from Lance, so we're not going
right?
to look at
In
that.
case there is a
Let's see
third
who
person.
else. Right, yeah,
And,
let's see who else there
and once
is.
he did that, she did not have two separate profiles after that identification of Lance Twiggs within the sample. That was the point.
On
Because
these
they removed
ones.
them.
But
On
whether it
these
was 90,
ones.
whether it's 95.5, and I think that you're mistaken in your hearing about that, Diligent, because later on in the recent testimony, she said the major sample referring to Tyler. It seemed that you may have mixed up 95.5. But regardless, even if
No,
it's
I didn't.
two,
She said the names. No.
fine, 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 fine. Even
She
if I'm
said
wrong,
respectively. She said Tyler and then Lance and then 95 and 5 in that
fine,
order.
fine, fine, fine. Let's just say
I'll play
it's
the
even
clip.
two. Let's say
It's
it's two.
it's pinned.
let's say it's 2% Tyler, 98% Twigs, for argument's sake. It's irrelevant.
They are
Because the
It
coping,
is
bro. I think
relevant.
wait, no,
it's
Sally, let someone finish a cogent point
No,
before you
it's
because
cut
you talk over
Sally.
references.
everyone and you spin narratives and we're spinning
Sally,
It
gold.
references. It
Sally, let me just
references.
finish a cogent point
We're
and then
gonna have
scream
a
at me that
back
I'm a
and forth.
retard.
We're gonna have a back and forth. You're not gonna
Let me just
come
finish the
start
point. Let me
talking
just
over me.
finish the
Hold
point.
on, hold on, hold on. It's not. You said something to me, and I'm going to respond. Right? You said that I had it wrong. I am going to clarify. I did clarify, but not only that, she's talking about the quantity of DNA to profile. Quantity. That's the percentages, right? How much of the DNA belongs to this person and this person of the total piece of pie of DNA on each object. 95 for Twigs, 5 for Tyler Robinson on the screwdriver, and respectively 11% for Tyler Robinson on the towel, and 89% for Lance Twigs.
Fine. No argument there. And I'll use an example that I think is a relevant way of demonstrating what I'm trying to say. Let's say there's a dish towel in my house. My wife does the dishes 95% of the time, and her DNA is going to be all over it. But then I grab that towel, and now my DNA is a tiny percentage. But the difference is Twigs is not placed at the scene of the crime. Tyler's
How do you
is,
know? There were
right?
3 people in that car. What if
Because
Twigs was one of those people?
it could be, but they have at this moment no
They're
evidence
not looking for
placed.
him. He's been in hiding.
Sally, are you allowing someone to finish a point? You
No,
could
because you
argue
bugged
with
the
me,
shit
but
out of
allow
me.
Just
me to
finish the
finish.
point. Just finish the point.
Yeah,
If
just
the
let me
more
finish
you
the point.
guys, okay, let me just say this: the more that we interrupt him, the longer he talks.
Exactly. Like I finish point
Just
quickly.
get to
The
it.
point is that it doesn't matter how much percentage is on the towel. The point is that his DNA, Tyler's, is on the towel, and other evidence places him at the scene of the crime. And at the moment, we have no
No, it
testimony.
doesn't. All of those people that we saw could have been Lance Twigs. They look almost identical.
Oh, I thought Lance Twiggs has long hair, but okay, fine. My point is, at the moment,
Long hair
the
can't
test.
be put up into a hat.
Oh,
Sure,
that
but
can't
hold on.
change.
I'll be
Oh,
finished in 2 seconds. At the moment, the evidence testified to, could there be something in the videos that say otherwise, that Twigs is there? Fine. But at the moment, the testimony is that Tyler's there. That's all that
Yeah,
matters.
you're basing almost all of your arguments and your opinion is predicated on testimony. Where if you haven't noticed, almost all of everybody else's opinion is based on the evidence. That's like you realize
Testimony
that,
is the
right?
evidence.
You
Maybe you don't know how
realize that,
court
right?
works. Maybe you don't know how court works.
Physical and forensic evidence. You are basing, I said, almost all of your position is based upon testimony that relies on institutional authority. It's all appeal to authority. You're not relying on any hard evidence. I said, can you ID him? Instead of answering that, you said, well, you said this person said he recognized him. You didn't. You have had plenty of time to go look at the footage, look at the pictures, right? But you can't ID him.
Man,
Nobody can.
in court,
Nobody can.
the jury makes decisions based upon testified evidence. They can't just say, well, maybe it's something else and make up their own evidence. There's evidence. If the
Nobody's making up
defense,
evidence, bro.
if the defense has a different theory, they have to bring evidence to counter that. But at the moment, the only evidence we have is testimony saying that video is a video of Tyler.
How's he an expert in U.S. law?
Where's the
I
video?
saw the video. We watched the video. All of us.
Oh, the Bigfoot image of him getting in the car.
Yes. Yeah,
Oh,
the
right,
one
right,
that
right.
had the bald guy driving with 3 other people in it, but we forgot
yeah,
the
that's so
the the
definitive.
testifying cop forgot to mention that detail when he testified because he's
And do
really
you remember the
honest,
other
right?
cop that turned his camera off too at the
Oh
perfect
yeah, the
time?
one that had the failing camera
Oh,
for
sorry,
the
he didn't turn it
DNA.
off. His
Oh, and I
camera
guess
died.
Lance Tyler could have grabbed a towel that belonged to Lance Twigs and wiped his hand on it. Therefore, he would have the smaller amount of DNA on it. But if it's the same case with the screwdriver, what exactly is Lance Twigs doing to the screwdriver where he would have the majority of DNA on it? Is he,
You don't
you
want to
know,
know.
yeah, I probably don't want to know, but that
Please,
doesn't
it
make
is
any
very
Hey,
sense.
costume.
Diligent. Bottom line is, I think we've got a problem. I think the Houston prosecution has a problem.
You
Bro,
know what, Dill?
they are getting annihilated. They have Donald Trump Jr. out here posting that no matter what, Tyler Robinson was at UVU 4 times.
I
Like,
still believe he's a killer. He's a killer in my eyes. I have Diligent. I've been meaning to bring this up to you. I have not heard of the chick that was seen with Tyler Robinson besides the one time she was brought up, but there has not only did I see like I'm pretty sure I saw a video of some woman being with Tyler Robinson. It was very quick, but no one's really said anything about that.
I don't.
After he was seen with a woman, like a kind of like a getaway situation. I'm not sure if this is on point or anything. It's still something that I've been meaning to mention to you every time you have a space with Charlie Kirk.
I haven't had it. I haven't seen anything credible to assert that that's real.
I'll have to look in videos that I've sent and like I've seen in the past. I'll find something and then send it to you whenever I find it. Sorry,
If you're on
guys.
stage,
Keep talking crap to
if you're
Mitch.
on stage and you have your hand up, please go. Okay, I'm gonna
Hey,
stop dropping
Diligent, if
people.
Don Jr. is posting stuff, what makes him a material witness?
Let's go to Rock 2 or Josiah. Somebody.
Yeah. So, I mean, obviously, this is a preliminary hearing. Standards are low. I don't think. I mean, if anybody on the stage doesn't think that the judge is going to find that there's enough evidence to proceed to trial, I'd like to hear it, but that doesn't seem very likely. The defense. I mean, the defense hasn't really tipped their hand on what their strategy is. At this point, it does seem like probably their best strategy is to say Lance did it, right?
Wait, do you think that the judge is going to find evidence to charge or to continue on with the trial for Tyler
Of
Robinson? Or do you
course.
think he's not? Yeah,
Oh, for
Yeah,
sure.
Of
they're
course.
gonna invent something.
They almost always do, right? Like it's very
Right. The
very
standard is
seldom that they
low.
don't.
Yeah, the standard is low, and there's definitely more than enough evidence to meet that standard.
Quote unquote evidence. Quote
and we're
unquote
not.
evidence.
Well, it is evidence, right? I mean,
Quote
you
unquote.
may not believe it, and actually, I mean, the standards are kind of lower for like what even counts as evidence versus at a trial, But
That's why I'm saying quote unquote.
like, there's just like, yeah. I mean, I think the case that they're making, in my opinion, is pretty strong against Tyler Robinson. We don't know what the defense is gonna like, what their alternative is gonna be. It does like I said, at this point, it seems like probably their best bet is to say that it was Lance, because that's how you could explain. You could come up with the alternate theory for the most of the stuff that's been presented.
If it's strong against
but
Tyler Robinson, then why would they have to frame it on Lance?
He's not saying that. He's saying
No.
that the best that he's offering plausible strategies for the defense. He's not saying that they have
Diligent, the defense has the ability to put forward the theory that this individual or some other individual is Lance Twiggs, and they have not done that. And I wonder, does Lance Twiggs already have an alibi that he was in a different location, a different city at the time of the shooting? So it's not even
according
a possibility.
to the charging documents, he was at home.
He was at home
in the other city.
Yeah. So if they can prove that,
but he lived alone. But he lived alone. So who's going to corroborate that? Does he have a camera in his house?
Diligent, what about the gun and the
you
ballistics?
Could use digital. You could use digital forensic evidence,
neighbors,
right?
Yes, exactly. Like that he was on his phone at a certain time. And
What about the gun
that kind of
and the
stuff.
ballistics? Are they going to tie that to Lance? They
I'm
got a
not
long
sure.
road ahead of them.
Well, based upon the alleged testimony that's going to happen, there will be DNA evidence and fingerprint evidence on the weapon.
We
and
don't
on the
going to
based,
happen.
based by the future tense alleged testimony.
Yeah, so I don't know.
Bro.
I'm just speculating, but if you were going to go with the Lance theory, what you would say is like Lance took Tyler's gun, used Tyler or the family gun or whatever it is. And so that's why, if there's Tyler's DNA, if there's even his fingerprints on it, that's how you explain that. It's like, it was his
Josiah,
gun.
this whole
He's
thing
used
is turning into speculation. Okay, if you want to talk about speculation, we got a whole lot of speculation going on here.
Well, he's just putting together the possible defense that they could have, Miss Lou.
Yeah, but
No, I understand, but on the other hand, we can't. This is so. I'm sorry, guys. I'm like tongue tied. I can't even talk about it. We can't even begin to speculate what they're going to do with all this now. It's a
Well, I
mess.
think the same way that this is just a preliminary hearing and this not the real trial and the evidence has a low standard. Well, the prosecution has to meet the standard of reasonable beyond a reasonable doubt, right? So
not for
as we
preliminary
are
hearing. Not for preliminary hearing.
stop interrupting me, Jesus.
I'm
So
sorry.
as we are offering these plausible other things, like most of the DNA consisting of Lance Twiggs, alluding that it may have been him. The individual looks a lot like him on the cameras, right? I'm offering ways that the defense can create reasonable doubt. They don't have to marry themselves to one theory. All they have to do is get one juror to think, oh my God, this is not 100%, right?
Well, so
This
that's
is not
not correct.
100%.
They do
Diligent, do
need.
you honestly think this is going to trial now?
I think, I mean, I have no idea. You can't guess that because
No,
a
I
lot of,
know. Yeah.
because the death penalty is on the table. And he might be afraid for his life and he might plead just on that. Even if he's innocent, he might plead guilty. I know a guy who was arrested and convicted of a pretty bad crime. He spent 20 years in prison, and then through DNA evidence, right? Through DNA evidence and the efforts of the victim, which is crazy, to find the real guy, because once it got picked up and she changed her story, she picked him out in a lineup. She changed her story. He said he was facing I think it was 30 years to life, and he pled down and got 20 years, right? Even though he said he was innocent, maintained his innocence up until the plea deal, because I guess you have to admit to it. Then one of those it was like Freedom Justice or some people who like actively try to corroborate long sentences for criminals. When he got convicted, DNA was collected, but it wasn't able to be profiled correctly because the technology wasn't there. It was old, like back in the early 90s or something, I think. And then 20 years later, they exonerate him on the DNA profile and find out it was another guy who was a habitual rapist,
And he sued
right?
them too, right?
He did sue, and he got a massive settlement. Well, they actually created legislation for him to so he could be reimbursed by the state, which I think it was like $300,000 or something like that, which is like a drop in the bucket to 20 years. But my point is, right, is that just because somebody pleads guilty when they're facing an incredibly hefty consequence if they don't, doesn't mean that they are actually guilty. It
It's
means
just to get a
that
lesser charge a lot of the
it's
time,
to
or most
get
of the
almost
charge.
all the time is to get a lesser charge. I would fight this tooth and nail, but the reality of the statistics don't lie. Whether or not he's guilty of this crime, there's a high probability he is going to plead guilty along the way, because after this is when the deal making starts. And his as a court appointed attorney, we read the statistic yesterday. 95% of cases handled by court appointed attorneys end in plea deals. 95%. Okay, 95%. So it is almost certain that he is going to accept a plea deal. Like, that's just something that we have to accept. Now, maybe his family will talk him out of that. I don't find it likely. From what I know from talking to the grandma is that the family is listening to the defense attorney. I think this defense attorney is putting on a show long enough to it's deal making time, and then I think she's going to convince the family and Tyler Robinson to take a plea deal. I think that's exactly what's going to happen. And it's unfortunate because I don't think that he is guilty of killing Charlie Kirk, in my opinion. I think it's likely he was involved with these fuckers somehow, right? Like I think he was likely involved, but I don't think he killed him. And I don't know this, right? But I think he was involved somehow. I don't think he actually killed Charlie Kirk, which means that if he does take a plea deal, everybody will move on, and Charlie Kirk's real killer potentially is still walking free. And all of the implications that go along with the death of Charlie Kirk will remain cemented in American history and in our country fundamentally will impact everything the way it has already, right? And so there is more here. There's a lot more that rests on the results of this case than just Tyler Robinson's future. A lot of our own future is tied up in this case, right? We believe that there's a corrupt government that is running wild away from a people that it is supposed to be working for. We've seen evidence of this throughout history. Even if you're still a diehard Republican, look what they did to Trump for 4 years, right? Look what happened with Epstein and now Charlie Kirk. The federal government, the bureaucracy, the agencies, they're renegade. And if we don't get people to wake up to that fact, we'll never fix it, and we will be ran by criminals. And that's exactly what's at the heart of this case, and a whole lot more. Let's go to Noah and Sally, and then we'll go to Blake.
Wait, I need to ask before this, Blake.
You ever put your hand up, Lune? Seriously, my
No,
hand's been up for 10
I'm just,
minutes.
it's not for him to answer me, just to mull over this, okay? I just want to know, when it's your turn, Blake, do you still think Candace is the murderer
No,
or somehow
I'm not
involved?
getting into that. Stop.
I'm
Noah, go ahead.
joking.
Did we notice that in one of the pictures, Tyler Robinson is wearing a maroon shirt and shorts, and there was a preponderance of young men with a maroon shirt and shorts on that day?
I did notice that. And if you look, the backpacks are different. We'll get into that. Did Candace point that out, Noah? Can
I
anybody
don't
hear
think
me?
she ever spoke specifically about Tyler Robinson, but I always thought it was this like a coincidence that she pointed out the maroon shirts and he had changed into one.
I honestly think, and I agree with Lady. I'm looking at the YouTube chat. Lady in Red says he was a decoy. I think that's what his role was. I think he was supposed to be a decoy. I think that's 100% what he was supposed to do.
We're still with Mr. Burt and Ms. Baker.
Here we go.
Direct
Sorry, you guys.
examination.
Thank you.
Mr. Burt, your witness.
Ms. Baker, would you take a look at, in your notes, page 24 of 379? Very bottom of the page. Did you write there on the 15th of September 2025, spoke with Special Agent Folger, gave update on report timeline, discussed it upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional. Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh,
Yeah, it should not be on the screen.
let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report, I'm sorry, the star mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twiggs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
I'd move that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through,
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder, for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're moving forward on this.
Sure,
Thank you.
thank you.
And so it may be published to all screens.
Bates number on this?
Yeah, it's page 39.
No, but the actual Bates number, I'm happy to provide the file and provide this to you now.
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are two contributors, right?
Correct, yes.
You input sample 7A,
Correct, yes.
and when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis,
Correct, yes.
right? And you put in sample 61, right?
Yes,
That's Twiggs's known sample.
Correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay, and then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of two different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those two numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamians.
And African Americans, yes.
African Americans. Another one for Caucasians.
Correct, yes.
SEH is Southeast Hispanics.
Correct.
And then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burtz.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to two samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
All right. Well, I understand what both parties are saying, and at a probable cause
The defense just
hearing,
said that
the issue is whether we walk 1 mile or 100 miles
the
down the
state's
path.
theory is that
And
Twigs
so I
is
want to
connected to
keep
the
it
crime
limited to
scene.
1
Did you
mile,
catch that?
and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so. But as it relates to where we're at, my hope is we can keep this very brief as
Yes, I
opposed to
can do
going
that.
through all this, so we can move on to whatever else you would like to present.
Thank you. We'll do that, Your Honor. And in the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
I'm going to need that up there because I need to do
Oh,
it.
so is it part of the same? Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to Plaintiff's Exhibit 31, which
I
has
see.
also
Okay.
been admitted.
Okay,
So
thank
they're
you.
both
I just wanted to clarify.
Sure.
All right, so if you, and do you want that published on this, all
Yes.
screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, and just highlight that. Thank you. So what we've blown up there is from your report, Plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay, and on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go, second page. Is this the likelihood ratio from your Twigs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twigs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twigs was a possible contributor or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twigs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twigs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the STAR mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run STAR mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twigs was a 912, right? According to your electropherograms?
That is correct, yes. Mr. Twigs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twigs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about
He
your
wrongly
interpretation
asserted
rules
it.
for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between 2 or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout. So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7.9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay.
She's getting
A
snotty.
couple more topics and then we're done. When you received this, the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack, correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we processed them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log, that was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract.
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those two together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the two would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the two of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay, and in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, with not
I just
applying
have
pressure,
one
just trying to
area left.
understand. Okay.
no, be done with it. We talked earlier about your testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by SDRs but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed, I believe. This is, could you bring up 34? This is not in front of the, on the public screen, just for the witness.
Okay.
And is this a chart that you reviewed, that I prepared to, and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each
Yeah.
location?
Yes.
Okay. I would move that into evidence. It's 5 pages, and it's Baker 34.
Mr. McBride?
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt?
Your Honor, this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could
Yeah,
you
it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay. And take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences, and that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twig's sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently, and I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness. And so the exhibit should not be admitted on its face either.
But that's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between, at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. The next chart will be the chart with the what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the Mr. I'll I accept Mr. Burt's representations to me out of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I want 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those three.
Correct, yes.
And similarly at VWA, where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right, I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at Well, I'll save that for redirect. Thank you.
Thank you.
All right, turning to the state. Mr. McBride.
Whoops. Good afternoon.
Good afternoon.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your bachelor's in biology degree,
what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner as well as the biologist, were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know, let's see, the directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So, for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Oh, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in or if it's found in a less or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there is some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about the PCAST report. You testified that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area, yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%, and the ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the Robinson?
When I calculated the statistic, Twiggs's DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker
Damn
4.
it, that was wrong.
An exhibit that was...
So one was the opposite.
Titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well... Do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Thank you.
Right, Mr. Burt? And how much time are you anticipating? Right.
You referred on cross-examination to your training and experience, right?
Yes.
Do you agree with this statement in the PCAST report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and that it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
Yes, I think there's one follow-up that needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
All right, thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into recess?
No, Judge.
All right. Having both parties say no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon. The court is in recess.
Good grief, that was a long one, man. It was
Diligent,
that
did she
defense
flip?
attorney.
Did
Hold
she
on, easy,
flip?
easy, 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 easy. The defense attorney, man, that one guy. Listening to him, I need him to adjust his vocal fry. You guys remember when I was having Grok talk a whole lot at the beginning, when I started using her in spaces, and she talked like this, and it sounded so horrible. She sounded like an 89-year-old, an 89-year-old, but 100-year-old smoker. That's what that guy sounds like. He needs a cold drink of some honey water. That was rough, man. That was rough. This is he just tried to do the same DNA discrediting tactics that defense attorneys always try to do, and it never works. It never works, right? That could have been saved for trial, and it's a useless. Like it doesn't always. DNA is a pretty you can if you can disqualify the source and the methods of DNA, but the methods of investigation or whatever. But when it comes to like actual um the actual DNA forensic examination, it's really hard to disqualify based on that. And when it's like the FBI institutional authority, like he was saying, right? I'm like you can make good points, but it doesn't typically work. AJ, am I right? I mean, you watch court TV.
Well, I watch trials. I don't know if I always watch court TV, but yeah, I don't understand why I think the judges were like, oh fuck it, like just finish what you have to finish because she was leaving town, so they have like limitability with them. But it was pointless, honestly. I think the
Fucking,
points
you
that were made earlier were better.
Did
could
she
have
flip?
been.
Did she flip what she told you? You sent a post out that we all heard that said Twigs had the majority
No,
of the
she did not
DNA.
flip. I corrected. She said Mitch was right partially. The first time she said 95% Twigs, 5%. Um, well, she said 5% Tyler Robinson, 95% Twigs. That was on one item. The second item, she just gave the ratio without saying the names. So the prosecution, which he did a good job here, he he got that extra. He's like, what? Who was who on the second one? And the second one was wrong. So I posted a correction actually.
But what
So
about the
that's
first? The first one was correct, right?
it's the same. Yeah. Yeah. So it was half. I was half wrong, and I correct. That's why I corrected it. So,
Seemed like he was
um,
leading her.
I am extremely tired. So I want to go through the hands-on stage. If anybody has any final comments, and then I am gonna wrap for the day. I am gonna go. I have to go do some run some errands, some investigative errands, and I probably will host a subscriber space later tonight. If you want to support what I'm doing, I'm out here on the ground covering the hearings all day. I went to the courthouse this morning and got Charlie Kirk's parents walking in without Erica Kirk, which is interesting because that's 2 days in a row now. Seems like she would come in with them. But it's whatever. Maybe not. And yeah, so if you want to support what I'm doing, the best way so I don't have to take sponsors is to subscribe. There's a pink button on my profile. Make sure you're following my lovely co-hosts, Harmony and AJ. They are ballers, always there showing up. AJ loves court stuff, so her knowledge is useful. Turn notifications on if you want. Yeah, and the best way to support me is by subscribing, turning all notifications on, and share my investigative content, please. Charlie Kirk, Epstein, or whatever. If I'm just rambling, talking shit, I don't need you to share that. But if it's on the ground or investigative content, please share that. And yeah, I will do a subscriber only after space later tonight. I'll do a short one later so we can kind of touch base. So we'll go through the hands on stage and then we'll wrap it up. I'm not going to bring up You can bring up Lunay if you want, but we're not gonna bring
Can
up
we
any new
bring
people
up
after that.
Bosco or no?
I don't want to argue. He always wants to argue.
I told him he could come up because he asked.
Okay.
Thanks.
Let's get through the hands. Ronnie, go ahead.
Hey, Dilly. Thank you, bub. I don't know what's been going on with your spaces the past couple of days, but they have been so glitchy, and I haven't even been able to come in. And I've had, I don't know if you've noticed how many
Let
times.
me. You subscribe, right? Let's do that.
Yes,
Save that
sir.
for the after space. Let's save that for the after space.
All right. Well, I'll talk about just the Charlie Kirk trial right now. So when it comes to Catherine Nestor, I went and did all the research and how many people were connected to the Mormons and stuff, and honestly, the defense isn't connected in any way. They're all out of California. Everybody else is connected is the judge, the uh, police, and the prosecution, and even a lot of them have been connected to Trump and Pam Bondi. So, and that also goes for Nestor as well. Nestor, she protected somebody in a past trial who was, you know, Pam Bondi and Trump. They wanted him in. So I don't know how, you know, really, I don't know how she actually is implicated in anything, but I will tell you this. If the defense was real, they would have presented every single piece of evidence. They would have damned the prosecution and said, "Hey, come at me." But instead, this was such a light trial, dude. It's
It's not a
just
trial.
almost laughable.
This is just the preliminary hearing. It's not the actual trial.
And they have to stay
Right.
within the scope, right? So it's limited
Yeah,
by what the prosecution
they're
presents.
very limited. I can't believe he entertained that fucking DNA thing. Like that was. I think a seasoned judge probably would have cut that short. To be honest with you.
Well, and when it comes to actual trials or even preliminary trials, I sued OpenAI last year, and everything had to come out forth. For anybody who's actually getting through a trial, you have to dodge so many case laws like Twombly and Iqbal and everything, and this was very moderate, and they honestly kind of failed Tyler Robinson right now, I feel.
Yeah,
Well,
but there's a huge difference between civil and criminal case trial. Like
I
it's
think
it's the different situations.
I think that well, they had an opportunity to ask who he met at TPUSA. Like it's a huge detail to just glaze over without any more digging, right? That made me I'm already sus about the court appointed attorney that's been in the federal system for 20 years. But now that kind of validates my concern. So, all right, thank you, Ronnie. Let's get Bosco out of the way. Go ahead, Bosco. Are you the Fed slop team is really, really kind of crying today.
What? The Fed slop team? I don't really know that term. But anyways, yeah, this is like a discovery of evidence or whatever, preliminary. And this like idea that the defense failed Tyler Robinson, there's clearly enough evidence to have a trial, considering the video, the DNA, probably other eyewitnesses. There's a lot of evidence that these people have to probably or possibly convict him. Now, I have a question, Diligent. If he's convicted, what can get you to actually get away from the theory that Mossad had Charlie Kirk whacked? Is there anything that could get you off that point?
I
Like,
have never espoused that theory.
okay, so is there anything that could get you on the
To
point
to
that
believe to believe that Tyler Robinson's the sole killer?
yes,
Compelling evidence.
okay, and would
So if
compelling
he
evidence be
pleads, if he pleads, right? If he pleads, and in the face of this, and there's no more investigation, that's the end of
well, he's
it.
not going to plead, Diligent. He's going to trial.
You don't know that. We don't know that.
Diligent. The fuck he's going to? Why would he plead? He's going to trial. They're in it
Because
to
it's
win
a
it.
death penalty case, bro.
But like, I don't. They're in it to win it. Like he's going to try to fight it.
Don't you
Hey,
think?
diligent. This dude has never been wrapped up in a legal case ever in his life. Probably never fought a traffic
It doesn't
ticket. He
matter.
has.
I'm just saying. There is. It's a death penalty case. If he gets it wrong, he dies. So if he wants to live, right, and they offer him a deal, which is life and no, not death, he might take it, right? Given like my notion is that he's likely involved but didn't pull the trigger or kill, right, or kill however he died, right? So that's my likely thing, and I don't think it's like Israel killed him, right? If anything, it was likely a boat, like our government. At the very least, our government allowed it to happen, right? As I don't
Well,
know. There's a lot of different factors there,
I just want
right?
to say, yeah. I'll say one last thing, and I'll let you know. You're trying to end this. I'd have to say this, right? Is that so? I mean, I know there's a lot of like narrative building as far as how a lot of people feel about this case, and that's what lawyers do too, by the way, on both sides, right? They narrative build because they're trying to create a picture that either you know damns or undamns this individual, right? And it's the same thing with a lot of people on Twitter with what they're going through. But if you believe, right, the even the trends or the entirety of Charlie Kirk would give Mossad or anybody an agency to whack him, right? Not Mossad, just anybody to whack him. That the doctored video of what he said at a specific time gives the idea that somehow he like woke up. The guy's been on camera for so many hours, and if you cherry pick it, it could look bad. That's all I'm saying. You guys nobody
No,
assumed
just
Charlie Kirk was turning
his
before he was killed. That's all I'm saying.
his I'm not assuming anything. I'm just going by his last known statement, which was leaving me no choice but to leave the pro-Israel cause, which was 3 weeks after Harrison Smith posted on Twitter that if Charlie Kirk left the pro-Israel cause, they were going to kill him. 3 weeks later, he says he's leaving the pro-Israel cause. 2 days later, he's dead. That's motive, at the very least.
I mean,
Now,
that's hearsay.
it's not hearsay. Charlie Kirk's text message was corroborated by Andrew Colvett, TPUSA spokesman. That's not hearsay. He said he was leaving the pro-Israel cause. 2 days later, he was dead. That's motive. I'm not saying that Israel killed Charlie Kirk, but Israel definitely had motive. That's a fact.
And again, I listen. I'm open to the idea that Israel killed Charlie Kirk. I just haven't seen the evidence, right, at all. And that's the thing. I am open to anything. Like I'm not, Mitch is not an American. Mitch is not an American. I give a fuck about this country, right? So
I'm open that he was a furry loving boyfriend that killed Charlie Kirk for his boyfriend, right? I'm open to that.
I mean, he did piss off the
possibility.
homosexuals, Diligent. Let's be honest. He did. The gays didn't like him.
No. They also listen. The like the furry community or the left, the LGBTQ or whatever, right? They also had motive. Like I'm not discounting that, right? And like I said, I think Tyler Robinson was involved at the very least. I don't think, like I said, I don't think he killed him, but I think he was likely involved. Well, I don't know for sure. And in the face of compelling evidence, I'm willing to draw a conclusion that might be different than what I'm leaning towards now. That's what we're supposed to do, right? In the
Yeah, as
face
an
of compelling
American.
evidence, we're supposed to shift draw conclusions as more information is presented. It just needs to be compelling. In this last 2 days, I have not seen one bit of compelling evidence given by the prosecution. Not one. We've gotten
Well,
we've
they're
gotten
not going to
Bigfoot
show their entire
videos.
life.
Anything. One
They're not going to
solid
show
thing.
they're not going to show their entire
We
leg.
got Bigfoot
Diligent, they're
videos.
not going to show their entire leg.
We got body cameras from 20-year veteran cops failing at the critical moments. We've got cops not remembering things, cops saying, I don't know, cops forgetting to say that the car he said he could identify Tyler Robinson from had distinctive rims, right? But oh, wait a second. The people who saw the car said some bald guy and 3 other people were in it. He just forgot to mention that detail during his testimony, right? Like there is nothing, I'm telling you, this 2 days has been a massive defeat for the Fed slop team. I'm sorry, but it has. Go ahead, Bosco. You can respond, and then we'll go to the hands. Did I lose you guys?
No, I'm seeing his mic went off.
Okay. All
I
right.
mean,
Anyways, thanks.
before you go, I mean, I honestly don't have any proof, and I've never said myself that I think Israel did it either, but I do appreciate you taking the time and going through it. I mean, everyone is watching the World Cup, and here we are, we're sitting here trying to figure out what actually happened. And when that cop said that the body cam just went out of battery, that was something I didn't even know. So, like, thank you for that. And thank you for Bosco for coming up too.
Go ahead. Sorry, Eddie. I noticed things, and Miss Lou.
Well, you and Bosco pretty much went over everything, man. It's the end of the night. God bless you, diligent. I wanted to ask you, what the hell goes on in these subscriber spaces? Because I was actually thinking about, you're the only one I ever thought about, man, doing this for.
I
So
usually
I was
just
just,
I usually just take feedback from my audience, from the listeners, and from my subscribers, and get their perspectives on like what we covered for the day. And sometimes I share what I'm planning on doing next.
okay, so it looks the same as what we're on right now, right?
A lot of
But
yeah
he takes
yeah.
his shirt off. He takes his shirt off
That
on the
is not
subscribe.
true. You don't.
Well,
Nobody
then
wants
I
that.
can't join then.
No, nobody wants
Bro,
that,
it's worth
including
it.
me.
I mean,
Nobody wants that, including me.
Diligent, I just want to say this right quick, man. Do these people that live here in this beautiful spot in Utah, do they know what they're thinking they're going to leave this for when they go to Missouri?
What?
Is this not the most beautiful state? Like this drive, I mean, I'm shocked
Are
that
you
that.
here? Are you here?
Oh yeah,
Oh.
yep.
I'm trying to bring Lune up. If you guys can bring her up, we can let her up.
Yeah, let her.
I
She.
won't leave Utah, and I was born and raised here because it's so freaking gorgeous.
It's too
It's
sterile here,
incredible,
man. It's really weird. There's no litter, right? There's no litter. There's no homeless people or bums, right? Like
Oh,
it's
there
too
is if you go to
clean.
Oh,
Salt Lake.
It's
Salt
nice.
Lake,
it's
you'll find the
it's
bums.
it's it's too clean, right?
bro.
Like
I can just
it's
sit here and just stare at this place. Like I don't. It's
there's
it.
literally no highway trash. There's no trash anywhere. I mean, usually you get
People
a
put their
little
carts
bit.
away too at the grocery
Yeah,
store.
I'm just saying, like, it's too sterile, right? It's like Stepford wives. It's fucking
How
weird.
expensive is it? How expensive is it?
It's it's like moderately expensive. It's not that bad, to be
Hey,
honest with you.
Diligent.
I think I paid. I mean, I'm in an Airbnb because I didn't want to be in a hotel for this. But I think it's not bad. It's not great, but like the gas is still a little higher than national average, I think. But other than that, it's all right.
Hey, Diligent.
Mm-hmm.
I was just gonna talk to the fact that you were talking earlier with like the Mormon Church. So I'm actually a member.
Mm-hmm.
Not a very good member, I would say, but you were talking about the likelihood of Tyler Robinson being set up as a patsy as far as like the culture of the church goes and whatnot. And I think what you were saying was pretty spot on because the church is pretty strict when it comes to traditional marriages and the view on like homosexual relationships and whatnot. That the church is pretty strict on saying that God wants marriage between a man and a woman. So, in theory, most people and 80% of the people in Utah are members of the church or former members of the church or their families are members of the church. That's just the way it is out here. But the thing is let's say if someone were to capture Tyler doing some activities, possibly watching some illicit, pornography or something weird like that, and they had blackmail on him. It wouldn't be a far stretch to say that someone could leverage some sort of blackmail on patsies in Utah. The other thing I wanted to bring up about the church is I wouldn't say the church is Zionist, like supporting of modern Israel at all. It talks a lot about the scattering of Israel because they were wicked and the gathering of it afterwards, but it's not referring to, my bad, it's not referring to the modern nation of Israel or anything like that.
I mean, that may have been true to that may be true to an extent and to some point, but
Yeah.
from what I've seen, just from talking to people locally, and then also
Yeah.
through my research, I know that for a fact, Israel does
Yes.
well, at
Visits
least
and stuff.
Zionists do like they do propagate here.
For sure. And I agree with that. But we also host lots of like other leaders as well. And the other thing is too, is like
Other
I was
leaders
losing my
from foreign countries.
foreign countries, like other faiths, stuff like that. We host them quite a bit.
What other
And I'm
foreign
not,
countries?
what was that?
What other foreign countries you guys host? Like
Well,
Hindus?
you
China,
see,
China.
yeah, you see other church leaders like the apostles, for example. And I'm speaking as far as the church goes. A lot of like the leaders of the church were successful businessmen and in the law and stuff like that. So they may have relations outside of what the church is. And I can't speak to that at all, right? And then also the other thing I was thinking is like it also depends like when they're picking the jury for the case. A lot of the older generation, and it's the same as pretty much the right. The older members of the right are pretty pro like trust the government because conservatives are in power right now. But I would say the younger demographics, even in Utah, are a lot more like have normal views, a little bit less trusting of government and all that stuff going on. Sorry, I got a weird cough. I'm trying not to cough, but
No, that's
yeah,
okay. I appreciate you not coughing on my space. Take a
yeah,
drink.
I'm
No,
all good.
thanks for your. I appreciate the local insight, and
Yeah,
feel free to come up anytime. We're going to be covering that a little bit more because his family's Mormon, and
yeah,
half of Charlie Kirk's team was Mormon, and
yeah.
a lot of the ones that were
Latter
acting
day
shady.
Saints, not Mormon. They're different.
That I
The
mean, that's
half
just
half
the
of
pro.
Charlie Kirk's team or Mormon
Yeah.
specifically, said by Charlie.
Oh yeah.
Okay,
And
not
and it makes
LDS,
total sense
Mormon,
that the CIA would draw
and the
from.
ones
Charlie's
that
not
were
Mormon. He can't speak for LDS. It's different.
they
No,
were
so
there. He said it at the assassination. We stop. Anyways,
it's
they
it's the
said
same
that
thing. It's
if you
just
just
like
let me
a
finish, just let me
oh my
finish.
bad.
So Charlie Kirk, half of Charlie Kirk's team was Mormon, right? And the ones that were acting shady as hell, Terrell Farnsworth, for example, Mormon, right? His camera guys who didn't even look his way when he got shot or whatever happened, right? When he died, they didn't even look his way. They immediately turned around and waited for him to be carried out. This kind of behavior, this was
Yeah.
not, this was, these were the Mormons that I saw behaving. Now, I'm not saying it was all Mormons or Mormons
No.
are the problem,
No,
but
absolutely.
obviously we need to look at this ideology
Mhm.
because there's something at play here.
Yeah, no, and I agree. Like I said, I'm not a very good member. Like I went and served a 2-year church mission when I was 18. I lived in Guatemala for 2 years, so I know the
Did you learn
doctrine pretty
Spanish?
well. Yeah, I did. Yeah, I don't speak it as
And
good as 10 years ago, but
yeah. Did the
um,
CIA try to recruit you when you got back?
no. But to me, when you're saying that, it makes total sense because, like, I was reading a paper a while back that was like saying that Mormons are great, like, is a great control group for like studies just because they haven't, had a lot of illicit substances or a lot of relationships. And I think in some ways that may make people susceptible to influence and control and kind of like a blank slate, if that makes sense, as far as like recruiting from the CIA would go.
Yep, that's exactly what was said.
Yeah.
Well, thank you. I noticed things. Feel free to request, come back anytime. I'll be here all week. I'm going to be hosting spaces on this all week. So I think we might get a break tomorrow. So they were saying the journalists, the reporters at the courthouse were saying that they might not start until 1 p.m. tomorrow. But given how late this one went, I'm not so sure. So we might be starting later tomorrow. Might not. I'm not sure. Who else is on stage that needs to go yet? Hasn't gone yet?
Yeah, let me just land this real quick, Diligent, on the Tyler Robinson narrative. It really needs to be explored. with the possibility of an illegal gun sale or some sort of gun transaction that Tyler was believing he was being a part of or was hawking a gun. The reason I say this is Truman Van Cott. This is, the quote unquote Nick guy that Candace talked about early on. He has mentioned this an awful lot of times to me, like unprovoked, unasked, like that he's kind of like he knows more, or that he just knows. He
Who
knows.
has? Who has?
Truman.
Who's that?
Truman is okay. Do you remember back when Candace in September, October? I mean, that's crazy to think back that long, but she talked about a guy named Nick, and it was an insider that had been talking to her and had information on Phil Lyman, and Phil Lyman showed up at his house.
No, okay, I do remember that.
You remember
Hmm,
that
yeah, young
story?
kid. Yep,
Yeah,
yep, yep, yep.
young kid, right. He ran for city council here in Orem. So he has mentioned, I've had a number of calls with him, and he's mentioned a number of times that he believes wholeheartedly that Tyler was believing he was doing a gun transaction. He he called it illegal gun transaction. Now, whether I mean, I don't know. It's just that there was a gun sale going on, and it was kind of possibly shady, where it was being left and then was going to be picked up by the purchasing party, like a non-contact kind of deal. So that just needs to be looked at, because it can honestly make sense where if Tyler's kind of driving around waiting for someone to make contact, or waiting for the next order to go and pick money up somewhere. I mean, these are just things that I can honestly see this happening if Tyler did in fact come to Orem from Washington with a firearm, with a rifle that day.
Something that I could say or add to that real quick, if you don't mind, is the
I
main
do
place
mind
to.
because I gotta go. I'm sorry.
Oh,
I
okay, you're
do.
all
I do.
good.
Yeah, this is kind of closing thoughts. You kind of came late to the party.
No,
Well,
it's all good.
yeah, but you come tomorrow and we can elaborate more on this. I've been streaming for 8 hours and 8 minutes, and then I was at the courthouse for 2.5 hours before that. So I am ready to wrap it up.
Nice work,
After,
dude. Hey,
thank
that's
you.
outstanding work, man.
Thank you. Miss Lou and Blake, yeah, just hit me
Quick
up.
question, D, because I know you're getting ready to settle up. Something to think about. Why, how much investigation has been done? Was he taken into custody, Lance Twiggs, in light of today's DNA effort? And is he
No,
going to possibly,
he's in Texas with his family.
well, he might want to be
He was
taken in.
granted he was granted immunity.
Oh, you're kidding.
Nope.
Okay, so he's not, he can't be listed as a conspirator.
If he's granted immunity, then even if he
Yep,
is, then yeah,
yep.
exactly.
Okay, thanks.
Yep. Which is interesting because even if there's another person involved, right, and they give Lance immunity, I don't think that you can, like, that might create a, well, I mean, the prosecution is not exactly being objective here, but even an objective prosecution, if there's three people involved, that's a conspiracy. But if they give him immunity, then maybe that only narrows it down to two people. I don't know. These people are so fucking corrupt, dude. I just wish they would just. I wish they would just be fucking normal. Just be normal. Do your fucking job like you're supposed to do. We pay your salaries. Quit trying. Just quit being criminal and pieces of shit, man. Just do your job. Stop killing our people. Just it's really we're things are really fucked. But I think that I truly believe this. The way some of these things have happened, I don't know. I'm a Christian. I don't know. I believe in God. I'm a Christian, and I think that some of the way these things are happening is beyond anyone's control. Right, the way that the truth has come out in so many different ways, I really believe that's God working, and so it doesn't matter how hard these people struggle to like hide the truth. or to be corrupt or keep control or influence how people see things or have have massive power in the United States to control people. I think that in the end, not even in the end, right now, God is working against them, and that's why they struggle and they throw fits and they thrash because they grow desperate, and because it's not something that they can compete against. They can't. It's not one person. It's not 100 people. It's the universe. It's God working against them, and they can't win. And that's something that evil people cannot accept. They have to win. They have to get the last word. They have to be in control, and they just can't. So we're gonna leave on that note. Thank you again, you guys. Make sure that you are following my lovely co-hosts, Harmony and AJ. Thank you, you two. You've been great today. Make sure you turn notifications on for them. They both host spaces. Katie, sorry I didn't hear from you, but we love you too. Make sure you're following her. And if you want to help support me, turn all notifications on. If you're on YouTube, like and share the channel with other people, and subscribe. Pink button on my profile, $5 a month. Little way for you, long way for me. And I will do a subscriber space later on tonight. Have a good night, everybody. God bless you. And I am going to go do some on the ground stuff tonight. And I don't know if I'm going to post it tonight or tomorrow. But yeah, it's going to be interesting. Have a good night.